Señoras y señores, les solicitamos volver a sus asientos. Señoras y señores, de pie, por favor.
Please rise. The court.
Muy buenas tardes.
Good afternoon. We reconvene this public hearing for the third session of participants. We welcome you. I now give the floor to the court's registrar to please give the necessary instructions as to this afternoon's rules. Considering the fact that we are running behind, we will be very strict with time. Thank you. Thank you, President. This afternoon we have the following institutions. First, the Center for Justice and International Law, CEJIL. Secondly, International Network of Civil Liberties Organizations. Third, Promise Institute for Human Rights, University of California, Los Angeles, School of Law. Fourth, Sustainable Development Clinic and Environmental Law of the Technological Autonomous Institute of Mexico, ITAM. Fifth, Notre Dame Law School Human Rights Clinic and Notre Dame Reparations Design and Compliance Lab. Sixth, International Observatory of Human Rights of the illustrious National Bar Association of Mexico. Seventh, ClientEarth. Eighth, the following organizations: Inter-American Association for the Defense of the Environment, the Foundation for Due Process, European Center for Constitutional Human Rights, VN International, Forest Peoples Programs, the Institute for Legal Defense, Jackie Duggard, Minority Rights Group International, the Project on Economic, Social, and Cultural Rights, and Open Society Initiative, Justice Initiative. Ninth, the Institute for Governance and Sustainable Development. 10th, Earth Rights Advocacy, based on the Global Justice and Human Rights Center of New York University Law School. I remind those appearing before the court to express yourself slowly and clearly to ensure smooth interpretation, and please let the court know who will be using the floor. Thank you. Thank you, Mr. Registrar, and as per the order, I give the floor to the Center for International Justice, CEJIL. Good afternoon, Honorable Inter-American Court and everyone present. I am Florencia Rejardo of CEJIL. with my colleagues Dalila Seane and Rosa Celorio. We will present our main arguments of the written observations, which were brought along with Julieta Rossi, Alexandra Junius, Claudia Martin, and Patricia Galbao. Dear judges of the court, we are aware of the complexity of the text you've been entrusted with. Although there are other advisory opinions on this matter, the expert opinion you can issue has the potential to be fundamental to give a new perspective of human rights to the climate crisis. Being the only court in the world with an express mandate in human rights, addressing an advisory opinion on the climate emergency, your decision may help us with proposals to address the crisis justly and in a sustainable manner that goes beyond borders. The abundant jurisprudence of the court in respect with the content and scope of the duties of prevention and guarantee under Articles 1, 1, and 2 of the American Convention regarding the right to life, personal integrity, equality and non-discrimination, as well as a healthy environment, should be the legal foundation to provide tools to states to respond to the climate crisis. This court has a tradition of interpreting and integrating several standards and frameworks, legal frameworks, in terms of human rights obligations. They've done this with humanitarian rights, rights of children, migratory rights, and the right to a healthy environment. The current climate crisis asks you to reinterpret the connections between the American Convention, other inter-American treaties, and the UNFCCC, the Paris Agreement, the Escazú Agreement, and the IPCC reports on the principle of due diligence, providing it with specific content. This submission will focus on two essential points. First, the applicability of the obligations of due diligence developed by this court, considering the risks of the climate emergency. Secondly, the relevance of this court providing elements to states to provide better answers for the most vulnerable groups in this emergency. I give the floor to my colleagues. Good afternoon, Dalila Seane for the Center for Climate Crime Analysis. As we heard, the court has already interpreted the scope of the obligations to prevent and guarantee in light of the American Convention. States must abide by these obligations following the due diligence standard. This court has been emphatic in terms of the obligations in environmental aspects lie upon this or are based on the due diligence duty. Given the climate emergency and the scientific evidence as well as political acceptance of it, there is a reinforced or enhanced due diligence duty. To understand what this means in the environmental scope, it is very useful to go to the doctrines of avoidable and foreseeable risk and the risk created that this court has already developed. In the case of Campo Algodonero, you see that an avoidable risk, the duty to prevent is activated in a situation of imminent and real risk for the human rights of a person that people should have been, that the authorities should have known or been aware of and had the possibility of avoiding. On the other hand, the risks, in the cases of created risks, such as the massacre of Pueblo Bello, states must implement actions to deactivate a situation of risk that is objectively generated by their actions. Now, what type of risk are we talking about in the current climate emergency? The Honorable Court, in its Advisory Opinion 23, has stated that states should take action to prevent significant damage to the environment, and that any damage to the environment may lead to a violation of the right to life or personal integrity and can constitute significant damage. The IPCC is the robust scientific consensus of the real risks of climate change, the loss and damages, and the disproportionate nature of impacts, as well as the need to take urgent measures to ensure temperatures do not go beyond the 1.5 threshold. Over a year ago, the IPCC said that there was little time left to avoid an increase of temperatures that would lead to catastrophic effects for life on Earth, particularly with disproportionate effect for the most vulnerable groups. This, at least, is a situation of real and imminent risk. This shows that the risk of significant damage to the environment brought on by climate change is clearly known by states, whether it is a matter of created risk or a case of avoidable and foreseeable risk. Therefore, this court has said that states are under the obligation to take the necessary action and adopt all the measures at within their reach in public institutions and private companies to avoid significant damage to the environment. It's an enforced and enhanced due diligence duty, not just because of the current climate emergency, but also because in light of international environmental law and the precedents of this court, we need specific measures that are intrinsically interrelated: mitigation, adaptation, and response to loss and damages, which means reparation. First of all, we should reiterate that we're talking about mitigation measures that are necessary and that can lead us to the reduction of damage. They have to be adopted quickly, considering the seriousness of the impact and situation. For example, adopting plans to effectively reduce GHG emissions, particularly methane, a drastic reduction of methane. Secondly, although it's not possible to give a close list of all the adaptation measures, we have to say that these should be appropriate and effective, based on participatory procedures involving the groups that are affected, and always under the guidance of a human rights approach to limit the impacts the climate emergency is creating or increasing resilience to climate change. How to ensure compliance of this mandate under the American Convention? States are to adopt a regulatory and financial framework that is clear and precise, guided by gender perspectives as well as diversity, interculturality, and intersectionality, as well as guaranteeing an effective implementation. This framework has to include not just mitigation and adaptation, but also the duty to perform environmental social impact studies and supervising activities of private actors, implementing actions to finance the actions in the climate emergency, and finally, procedural rights linked to the environment, such as access to public information, participation, and access to justice. Thank you. I give the floor to my colleague. Good afternoon, Rosa Celorio. I am Dean and Professor of Law in George Washington University Law School. As the IPCC has stated, the states have to consider the fact that the crisis has special connotations for groups and communities that live in a situation of vulnerability, marginality, and exclusion in our hemisphere. And it also includes the duty for reinforced or enhanced due diligence. With this in mind, I wish to highlight the important jurisprudence of this court geared towards the respect and guarantee of rights for these groups, and these can serve as a starting point to clarify the reinforced duties of states in the context of the climate emergency, as we're talking about a phenomenon that is intrinsically discriminatory and of a intersectional nature. I will give two specific examples to prove the point, which may guide the court in developing its differentiated approach. Firstly, climate change and natural disasters worsen violence, discrimination, care work, and give way to a loss of autonomy of women and economic independence of women, but particularly in the case of indigenous women that have a special connection and a spiritual connection to their territories, natural resources, and culture. The court may demand states to contemplate these risks so that they include participation and voice of the affected women, developing plans of adaptation with a gender-based perspective. The legal basis for this jurisprudential development should be the symbiotic interpretation of the American Convention and the Belém do Pará Convention. The second example is indigenous peoples who daily live the noxious effects of natural disasters and climate conditions in their territories, as well as over their natural resources, survival, livelihood, and cultural activities. This means they have greater barriers to access food, water, and quality health care. It leads to migration and displacement, and it increases their exposure to economic activities of states and companies without their prior free, informed consent. The court can guide states regarding necessary adaptation measures for those who are in the most affected areas to access their territories and natural resources. Among others, other rights, following the lines of Daniel Billy et al. Of the Human Rights Committee of the United Nations. Indigenous peoples are key actors to give response to this climate emergency, and their knowledge has to be considered in defining mitigation and adaptation measures. To close, we would ask the court to take this historic opportunity to integrate inter-American standards that have been consolidated to the climate emergency, and to expand upon them with broad scope for the most vulnerable groups, promoting a response to the crisis that is based on a human rights approach. Thank you very much for the opportunity. We are very hopeful in this process. Thank you for the space and for your very important work.
I'd like to thank the representatives of CEJIL for their participation. Next, I will recognize the International Network of Civil Liberties Organizations. Thank you, Madam President and honorable judges.
Present 10 members of the International Network of Civil Liberties Organizations, NGOs operating on 5 continents. That civil society groups from all corners of the world joined forces in these proceedings testifies to the global concern about climate change and the importance of the court's advisory opinion. Even though many of the world's major polluters are outside the court's jurisdiction, your findings will reverberate well beyond the Americas. The international persuasiveness of the advisory opinion 23 on the environment and human rights was such that the Supreme Court of India relied on it to find in a recent order in Ranjai Singh against the Union of India that, I quote, "Despite a plethora of decisions on the right to a clean environment, some decisions which recognize climate change as a serious threat and national policies which seek to combat climate change, it is yet to be articulated that the people have a right against the adverse effects of climate change. This is perhaps because this right and the right to a clean environment are two sides of the same coin. As the havoc caused by the climate change increases year by year, it becomes necessary to articulate this as a distinct right." End of quote. So it was recognized as a facet of rights to life, personal liberty, and equality. Much has been written and said, especially yesterday, about the difference of the present advisory proceedings from those before the International Court of Justice and the International Tribunal for the Law of the Sea. Yet even those who take this stance, like the Republic of Barbados, invite the court to merely read the whole of international climate change and transboundary harm law in the American Convention. It is out of question that the UNFCCC and the Paris Agreement should be taken into account when interpreting the Pact of San Jose, as required by the Vienna Convention on the Law of Treaties. But international climate change treaties create mutual or erga omnes obligations between the states, not individual rights. For these reasons, climate change treaties, taking them into account, cannot mean copy-pasting them. So we call on the court to develop a human rights law regime for combating climate change, interpreting the American Convention pro persona, as it consistently does. Rephrasing Judge Vera Montri's famous words in his opinion in the Gabchikovo-Nadimarash case, if climate rights are human rights, this court needs to provide guidance as to how individuals may exercise their convention rights in the context of climate change. For this purpose, a workable construction of jurisdiction, standing, and merits review is required. I will deal with them in turn. Firstly, jurisdiction. It is the nature of climate change that its harms cannot be traced to a single source of greenhouse gas emissions. This means that the approaches to transboundary environmental harm cannot apply. European Court of Human Rights, in the recent decision of Duarte Agostinho and others against Portugal and others, accepted that with regard to jurisdictional issues, climate change reveals special features: the ultimate state control over greenhouse gas emissions, the causal relationship between the emissions and rights of individuals outside the state's borders, and the existential nature of the problem for the mankind. Illogically, though, this was not enough to establish extraterritorial jurisdiction under the European Convention. But even this court's interpretation of jurisdiction in the advisory opinion 23 is not automatically transposable to climate change, as it would require potential applicants to establish a causal link between specific greenhouse gas emissions and the effects of climate change on their rights. This is a threshold too high for individuals to meet in view of the contemporary scientific knowledge. A solution can be found in international human rights law. The harms of climate change are such that right to life may be engaged. So under Article 6 of the ICCPR, as interpreted by Human Rights Committee's General Comment 36, states are under a duty to protect life from activities, I quote, having a direct and reasonably foreseeable impact on the right to life of individuals outside their territory, including activities undertaken by corporate entities based in their territory or subject to their jurisdiction. End of quote. This approach has recently found support in Principle 29 of the Strasbourg Principles of International Environmental Human Rights Law and in Principle 9b of the Maastricht Principles on extraterritorial obligations of states in the area of economic, social, and cultural rights. Even if non-binding, both documents are the product of work of many leading academics and practitioners in their respective fields. Madam President, I turn to the issue of standing. Who can complain of deficiencies of state policies to combat climate change? European Court of Human Rights wrote in the recent Verein Klimasenioren Schweiz against Switzerland that individuals must be subject to a high intensity of exposure to the adverse effects of climate change, and there must be a pressing need to ensure those individuals' protection. Not only this puts the bar too high to clear and does not account for the global nature of climate change harms. This interpretation is not even based on the European Court's own case law on standing. It was developed specifically to inhibit litigation, so should not be followed. Equally, the causal link between greenhouse gas emissions and damage from climate change cannot at all times be proven, but is still required under the Court's Advisory Opinion 23 and the views of the Committee on the Rights of the Child in Saki and others. Mindful of the problem, and by reference to the European Court's Pavlov and others against Russia, this court adopted the standard requirement in the recent case of Habitantes de la Arroya against Peru. It held that in order to complain of environmental damage, no resulta necesario demostrar la causalidad directa entre las enfermedades adquiridas y exposición a los contaminantes, and that the potential victims need to show que efectivamente estuvieron expuestas a la contaminación ambiental de forma tal que su salud estuvo en riesgo. This is a test individuals may reasonably be expected to meet when also complaining of exposure to climate change. It is also consistent with the body of international environmental human rights law, starting with Fadeva against Russia, if not earlier. Members of the groups vulnerable to harms from climate change are best placed to meet the test. Finally, Madam President, both jurisdiction and standing are closely linked with the adjudication of climate change-related complaints on the merits. Together with the Inter-American Commission, Sabine Center, ClientEarth, and others, but unlike Mexico, they call on the court to rule that the American Convention requires the states to reduce greenhouse gas emissions as a matter of result. Where we agree with the European Court's Klimasenioren judgment is that the obligations of states to guarantee right to life and to protect private life require to adopt targets and timelines to achieve carbon neutrality based on carbon budget or other evidence-based methods, and this solves one of the problems raised by Colombia yesterday, namely on what basis nationally determined contributions should be established and reviewed, and I think also response to one of the questions earlier put by Judge Gomez today. Then the obligations are to set out intermediate greenhouse gas emission reduction targets to comply and ensure compliance with the targets and keep them updated. The state's climate change policies should be designed and enforced to avoid a disproportionate burden on future generations. The order of the Supreme Court of India in Raji Singh clarifies the intergenerational nature of adjudication in climate change cases. In the words of Chief Justice Chandrachud, it balances, I quote, immediate needs with long-term sustainability, ensuring that present actions do not compromise the well-being of future generations. It acknowledges that solutions to today's challenges must not only address pressing issues, but also lay the groundwork for a resilient and equitable future, end of quote. Madam President, we invite the Court not to settle on procedural or due diligence obligations. Access to information, public participation, impact assessment, all exist in international environmental law for decades. So if they were sufficient to avert climate change, there would be no need for the present request and no climate change in the first place. This concludes our observations, unless we, of course, can assist the Court further.
Muchas gracias. Le agradezco mucho a la organización que representa.
Thank you very much, and thank you for the organization that contributed the contributions to this hearing. We will now hear from the representatives of the Promise Institute for Human Rights, University of California, Los Angeles School of Law.
Thank you, Your Honors, for the invitation to be here. My name is Priya Morley. I'm the director of the International Human Rights Clinic at UCLA Law School and the Racial Justice Policy Council at the Promise Institute for Human Rights. My testimony will focus on the first part of our amicus brief, which my clinic prepared with and on behalf of the former UN Special Rapporteur on Racism, Professor Tendai Achume. The primary argument of our submission is that the global ecological crisis is simultaneously a racial justice crisis, and a racial justice and equality perspective is crucial to understand and respond to the differentiated impacts of climate change. Racial subordination and injustice are central to the processes of resource extraction, industrialization, and consumption that created and continue to drive the ongoing ecological crisis. It is racially, ethnically, and nationally marginalized people and groups who live in racial sacrifice zones and bear the brunt of pollution, biodiversity loss, and climate change, as well as resulting displacement. This term, racial sacrifice zones, describes regions that have been made dangerous or even uninhabitable due to environmental degradation. These regions are primarily in the global south and include ancestral lands of indigenous peoples, territories of small island developing states, occupied territories facing drought or environmental degradation, as well as racially segregated neighborhoods in the global north. Because they are disproportionately located in racial sacrifice zones, racially marginalized people and groups face disproportionate harms from the climate emergency, and yet possess fewer resources for adaptation and mitigation. The climate emergency also impacts racially marginalized people and groups in qualitatively different ways than other groups. For instance, some violations are specific to indigenous peoples, as my colleague Joe Barra will particularize in his testimony. Conventional responses to the climate emergency often overlook racial discrimination, instead favoring a socioeconomic perspective that is disconnected from race. We urge the court to avoid a colorblind approach to climate justice, which treats individuals and groups the same, even if they are differently situated due to historical projects of racial subordination. This would fail to capture how indigenous and Afro-descendant peoples are disproportionately impacted by climate harms. Instead, in clarifying the scope of states' human rights obligations in relation to the climate emergency, we urge this court to foreground principles of non-discrimination and equality in the international human rights law. This requires addressing not only explicit racism and intolerance, but also indirect and structural forms of racial discrimination. This also requires the adoption of an intersectional analysis which captures the interaction between two or more forms of discrimination or systems of subordination. An intersectional approach reflects how certain groups, like racialized women or migrant populations, face specific challenges in the context of a climate emergency. We also ask the court to affirm that for states to meet their non-discrimination obligations in the context of the climate emergency, they must protect racially and ethnically marginalized people and groups from the adverse impacts of climate change and ensure that they do not face discrimination in claiming their human rights, including in the context of climate-induced displacement. We hope this court will build on its own jurisprudence and encourage states to take a structural approach to reparations that not only repairs internationally wrongful acts, including racially discriminatory human rights violations that arise from the climate emergency, but also consider the legal, economic, social, and political structures that enabled historic racial discrimination and which continue to sustain racial discrimination and inequality today. We urge you to draw on the expertise of civil society, movements, and impacted communities to particularize the form that structural reparations could take. Thank you, and I remain available to provide any further information that your honors may require.
Thank you, Your Honors. First, I wish to pay respect to the traditional caretakers of this land, the Taino and Kalinagu peoples. My name is Joseph Berra. I am the Human Rights in the Americas Director for the Promise Institute, and also a member of CARC, the Caribbean Central American Research Council. I will focus on one component of this racial justice perspective, the protection of indigenous and Afro-descendant peoples' collective property, and urge this body to reinforce and strengthen inter-American standards on the rights to collective property, self-determination, and free, prior, and informed consent. States are failing in their obligation to recognize and provide judicial protection for the traditional territories of indigenous and Afro-descendant communities, as this court well knows from the cases it has heard, and which represent but the tip of the iceberg. This failure exacerbates other human rights violations and undermines indigenous self-determination. Private third parties and businesses take advantage of extreme power differentials and the dominant legal regime to appropriate collective property and engage in land grabs. The Western model of private property and land as a commodity dominates the approach of external actors, including state agents, and especially at the municipal level. There is little appreciation or understanding of traditional collective property regimes. Hence, states are complicit in the ongoing settler colonial dispossession of indigenous lands through a racialized bias favoring third-party actors by failing to respect and protect the customary law of these communities and the character of the land as inalienable and not subject to seizure or prescription. Moreover, in the struggle over land and resources, states have failed to respect and protect the autonomy of indigenous structures of self-governance. This is especially evident in the drive to access resources on indigenous lands, including those resources that are part of the green economy. Both state and private agents exercise undue and often corrupt influence in these struggles, resulting in the erosion of indigenous autonomy and self-determination. This court has played a leading role in the progressive development of the rights of indigenous peoples. I therefore urge this court to, 1, strengthen state obligations to respect and protect the collective property of indigenous peoples. 2, reiterate and clearly define states' obligation to obtain free, prior, and informed consent for major development projects impacting indigenous lands and resources. And 3, provide guidance to states to ensure that processes of consultation and free, prior, and informed consent respect and protect the autonomy and self-determination of indigenous peoples. This court should urge the creation of a special rapporteurship on the rights of indigenous peoples and a permanent working group on those rights within the inter-American system to ensure that indigenous voices are not only heard within the system, but also contribute substantively to develop the rights of indigenous peoples as they relate to the climate emergency. Strengthening indigenous self-determination and autonomy is key for addressing the human rights impacts of the climate emergency. And it is reparative, not only for indigenous peoples, but also for the broader society, all of us. Autonomous indigenous communities thriving on their traditional lands with protections for their collective property and determining their own paths of development and relation to the land benefits the rest of society. Collectively, it will lead to the creation of alternative models of stewardship and relationship to the land, distinct from the neoliberal model driving both the climate crisis and the response to that crisis. Finally, I wish to provide testimony drawn from the final section of our brief prepared by our colleague Kate McIntosh, who could not be present, regarding the prevention of grave climate harms and the protection of vulnerable communities through the codification of the crime of ecocide. States have a duty to prevent human rights violations, including by third parties. And in the case of grave violations of human rights, prevention includes criminalization, investigating violations, prosecuting those responsible, and providing redress to victims. Severe and either widespread or long-term damage to the environment is a grave violation of the human right to a healthy environment, as well as of other fundamental rights. Such damage should be prosecuted as the crime of ecocide. States should further support the codification of an international crime of ecocide corresponding to the gravest violations of the right to a healthy environment, on a par with other international crimes such as genocide and crimes against humanity. This was first proposed by the International Law Commission half a century ago. Indigenous voices across the Americas have been at the forefront of calling for ecocide to be made a crime. Many understand ecocide as a form of genocide, in line with the view that we share with Mother Earth and with our non-human relatives. And this aligns as well with an ecocentric perspective and recognition of the legal personality and rights of nature. The translation of human rights obligations into criminal law is especially important in the domain of environmental rights, as it introduces accountability for influential private actors, such as leaders of large corporations, which are often the source of the gravest environmental harms. An international crime of ecocide would also open up the potential for accountability in situations where the state is weak or complicit in the corporate destruction.
Señor representante, ha concluido su tiempo. Tiene un minuto para terminar.
Your time is up. You have 1 minute to finish.
This crime goes towards fulfilling the state obligations of effective judicial remedies, but it should complement, not displace, more structural remedies which are included in the framework of reparations. States must make reparations for the crime of ecocide as other grave human rights violations rise into international crimes. Thank you, Your Honor.
Muchas gracias.
Thank you for your participation. I now give the floor to the representatives of Notre Dame Law School, Human Rights Clinic, and Notre Dame Reparations Design and Compliance Lab.
Court. My name is Professor Diane Desierto. I am joined by my colleague, Professor Francisco Urbina. Excellencies, in yesterday's hearing, Judge Gomez addressed questions to several states on the potential about the court's dialogue with other international courts, and more poignantly, what message the court was expected to give about the nature of damage from transboundary harm here. We submit, Your Excellencies, this court has always powerfully spoken not just to other courts, but to present and future generations of the inter-American system and the rest of humanity through the authoritativeness of its judicial decisions. The advisory opinions of this court are themselves subsidiary sources of international law. They provide not just interpretive guidance and normative clarity, but unlike the advisory opinions of the International Court of Justice or the International Tribunal on the Law of the Sea, it is only this court that applies conventionality control to its advisory opinions. As the court very rightly pointed out in its 2014 advisory opinion on the rights and guarantees of children in the context of migration or in need of international protection, as well as its advisory opinion on the institution of asylum in 2018. The message that this court gives through its judicial decisions, contentious or advisory, is thus always purposive and intentional to achieve effective respect and guarantee of human rights and to advance the same goals of the inter-American human rights system. Excellencies, there are two undisputed points that we wish to bring first to the attention of the court as a matter of law. First, that there is no dispute on what is scientifically and legally required at this point in time for all states parties to the UNFCCC as to the climate actions on mitigation to achieve net zero neutrality and avoid further transboundary harm. On March 15, 2024, the UNFCCC Conference of Parties reported 5 decisions, legally binding decisions, that were taken on the outcomes of the first global stocktake, the Global Goal on Adaptation, the Just Transition Work Program, among others. These decisions were issued after we filed our brief in December, and they are now part of the corpus of applicable law on climate change that should be considered today. Second, Excellencies, there is no dispute that the 12th paragraph of the preamble to the Paris Agreement expressly obligates states parties taking action to address climate change to respect, promote, and consider their respective obligations on human rights, the right to health, the rights of indigenous peoples, local communities, migrants, children, persons with disabilities, people in vulnerable situations, as well as the right to development, gender equality, empowerment of women, and intergenerational equity. This is the very object and purpose of the treaty that is the Paris Agreement, and the entire regime that was built therein under Article 2 objectives was constructed with that understanding. The question, therefore, before this honorable court as it deliberates on its message to the world is this: what does it mean then for states, especially the states in the inter-American system, that have to take climate actions to respect, promote, and consider their respective human rights obligations? We invite the court's attention in our brief to the international legal principle of effectiveness, which contains 2 elements: that we must strive for interpretation of multiple treaties simultaneously by giving effect as much as possible to each and every obligation, and second, to ensure that the interpretation of these treaties are evolutive. These are legal tasks that are inherent to the judicial function and appropriate to this court. You have heard thus far from the many testimonies and the hearings of the multitude of urgent remedial actions for differentiated climate vulnerabilities, risks, and materializing harms as we speak. However, Excellencies, all of these demonstrate a common gap, an architectural pathology that this court alone can structurally address. While states are committing to enable themselves to undertake climate actions towards net zero neutrality, they are doing so under non-binding, voluntary declarations under their nationally determined contributions. This means that if they fail to meet the benchmarks that they set in the NDCs, there is no legal consequence under international law for the failure to realize those particular voluntary commitments. As we have shown with our quantitative and qualitative data from the Notre Dame Reparations Lab's climate change reparations data set, even among national, regional, and international tribunals in the world, there's been so much variability on pecuniary and non-pecuniary climate reparations, much more so even further variability when reparative measures are enforced or implemented. Because of this asymmetry, where you have an overwhelmingly binding, far-ranging, applicable international law for this global climate emergency, and yet have asserted non-binding and non-law nature for NDCs, we believe, Excellencies, that this court can generate the much-needed urgent human rights outcomes at the highest structural level of greatest impact for the rest of the world. This is why our proposal, as we have stated it in the brief, is twofold. And one is to enable, because of the mandate of this court, to require states in the inter-American system to conduct a human rights audit in regard to what they are already committing today under their existing NDCs and whether those are consistent with their obligations under the American Convention and related norms. No one has done that thus far, Excellencies, and no one is being compelled to do that. The second is to require that in the design of the next NDC, which, as the International Union on the Conservation of Nature spoke about powerfully this morning, and we agree with them, in the design of the next crucial NDC that will be path determining for how we approach the escalating climate crisis, Those NDCs have to respect, protect, and fulfill international human rights law as it is mandated in the preamble of the Paris Agreement and as is consistent with the American Convention on Human Rights. The NDCs, Excellencies, are being formulated by states with no compulsory obligation for wide consultation, for transparent information, for inputs from all stakeholders, especially the most vulnerable. And this is why we have the reality today of a widening net of mass national litigations that have variable results, whether they be in the Netherlands or in the United States, which have not been effective insofar as meeting those targets are concerned. In the only instrument where the major emitter, China, submitted an instrument to the International Tribunal on the Law of the Sea, they took the position that these are all just voluntary. The NDCs are just voluntary and they can opt out of them. But in any event, they were doing the best that they could. The United States takes a similar position, and to this end, we invite the court to consider that something that is feasible and immediately doable now that will compel this kind of discourse and dialogue that is inclusive and participatory for the most vulnerable, but as well as all those who are affected by the climate emergency could take place under the auspices of the orders of the court. I yield to my colleague, Professor Urbina.
Con su venia, Presidente.
If I may, I will do the rest of the presentation in Spanish. I am a professor at Notre Dame. I know we don't have much time. We are interested in bringing 2 points regarding the respect for democratic institutionality in the context of climate change. I will only mention the first and develop the second point briefly. As for the first one, it's the idea of separation of powers, which is an essential pillar to democracy and an essential aspect of the Inter-American Charter. And I just wish to enunciate the principle we would like to suggest, which is compliance by states of their conventional obligations regarding climate change, the responsibility of all the state powers, the executive, judicial, and legislative branches in their constitutional powers. And within these 3 powers, there's a strategic power for the legislature. The second issue we would like to address is the suspension of guarantees. The request for the advisory opinion talks about a climate emergency. We believe it is important for the court to explicitly use the language saying that emergency is different in science and civil society than in the convention. In the convention, an emergency can be caused to suspend guarantees. In this sense, the Honorable Court has the opportunity of providing guidance regarding suspension of guarantees in a context of climate change, and it can suggest that the fact that a climate emergency is not an emergency as under Article 27. The fact that we have change affecting all states in itself is not reason enough to suspend guarantees. If we take it differently, it would lead to a differentiated use of suspension of guarantees. Now, that does not mean that a specific situation such as drought could lead to the suspension of guarantees, but the climate crisis in itself, throughout all its duration and expansion, is not just cause to suspend rights. As the Honorable Court has said, suspending guarantees is something temporary and exceptional. You just have 1 minute to close. Thank you. It is a statute of exception, such as suspension of guarantees, is not enough to address a full approach as we have. We are ready for questions, and thank you for comments.
Thank you to the University of Notre Dame for their participation. Now we will recognize the representatives of the International Human Rights Observatory of the Mexican Bar Association. You have the floor. Thank you, Madam President, and good morning. My name is Alexis Cervantes. I'm a member of the Mexican Bar Association, and I'm here on behalf of the International Human Rights Observatory. Greetings to the President and the other members of the court and members of the audience here with us. And thank you for this opportunity to share the highlights of our written brief with you here. And in closing, and before I go into the topic at hand, I'd like to thank Yvonne Georgina Tovar Silva, who unfortunately wasn't able to come with us today, but is one of the main authors of our written brief submitted to the court. In order to clarify our submissions, we are going to divide our presentation into three parts. First of all, we'll talk about our interpretation of the obligations incumbent upon states in view of this climate emergency as a consequence of the duty to prevent and guarantee human rights. We'll also speak about the convention, the obligations under the convention to protect and prevent for when it comes to environmental defenders, women, Afro-descendant communities, and indigenous communities in particular. And in closing, as a final part, we will focus on the state obligations that we believe should be there to preserve the right to life in light of science and human rights, and especially about the importance of the right to access information and to transparency in this fight against the climate emergency. With that, and now going into point number one, as to the duty to prevent and guarantee rights in the framework of the climate emergency, there are two obligations that we believe are incumbent upon the states. Well, the first one, in designing public policy on climate change, the state must consider the specific effects on those persons who are especially vulnerable, as is the case of women, indigenous peoples and communities, people in transit and in migration, the elderly, persons living with disabilities, and persons living in poverty. The state must create channels of communication and incorporate their needs in designing public policy, and they must be heard, but not just one, on an ongoing basis. Actually, there must be a follow-up as to the development of these vulnerable populations. We need rules to take them into account at all times. Let us be reminded that in humankind, those who are poor and vulnerable are the first to die, and in largest numbers. They're the ones who are most prone to disease and to experiencing damages from climate change. Let us not forget as that when the aristocrats get a cold, it is the working class that dies of pneumonia. So it is important for states in their policymaking bear vulnerable populations in mind. Number two, the second obligation, actually under point one, it is crucial for the states to create mechanisms to obtain the best available scientific information, and when appropriate, traditional knowledge of indigenous populations, and of in order to include them into those policies and actions. And also under the Paris Agreement, states must guarantee traceability. They must be able to produce the information that they are using as a basis for policies and steps being taken to protect the environment. These activities, these obligations must be monitored and must be reported on by states on a regular basis. As to the second point about the protection of environmental defenders and other vulnerable groups. In this regard, and as per the American Convention on Human Rights and its additional protocol on economic, social, and cultural rights, the Escazú Agreement, and ILO Convention 162, states must guarantee a safe and enabling environment for persons, groups, and organizations promoting and defending human rights when it comes to the environment may operate without threats, restrictions, or perils. And women defenders, indigenous communities, farmer communities, and Afro-descendant communities are vital voices in fighting climate change. They must be reassured that their right to life, humane treatment, freedom of expression and opinion, and right of assembly are fully guaranteed in the legal frameworks of the states. And that is why states must take the necessary, effective, and timely steps to prevent, investigate, and punish any attacks, threats, or acts of intimidation brought against environmental human rights defenders in the enjoyment of their rights, especially when it comes to a climate emergency. It's fundamentally important for the state's legislation to include provisions about the due protection to be extended to these persons. And as to the last point, it is extremely important for us to underscore the role of access to information and transparency to preserve the right to life and survival, a livelihood, also in the face of the climate emergency. The right to access to information in this area allows us to understand the causes and consequences of the climate crisis, and furthermore, it creates awareness in people, companies, and other stakeholders as to the need to face this problem and address it. This responsibility is incumbent upon all of us, but we believe that this responsibility is undertaken when everyone in society, states, governments understands what this is all about, and there is information available about the topic. That's why there's a need for rules forcing states to be completely transparent when it comes to climate change. In that regard, the Escazú Agreement is especially relevant, as is the Paris Agreement. And under the principle of maximum publicity and bearing in mind maximum vulnerability, persons and communities, the states must authorize the authorities to generate, collect, and make available to the public and disseminate relevant information so that in a systematic, proactive, timely, and user-friendly manner it be made available. And this must be done on a regular basis. The technological breakthroughs that we see every day, the impact of artificial intelligence, the new components that we see on a daily basis may have an impact in the area. So we need to be up to date in that area, and that information needs to be reliable and comprehensive. It's essential. Let us be reminded that information is power. It is our input as citizens, as a society, to be able to fight major problems such as climate change. And that is why we would like to ask this court to recognize and promote with states the need and the importance of transparency and access to information agencies within the state. These agencies have a vital role to play in fighting climate change. And today, unfortunately, as an example, in Mexico, our transparency and access to information agencies are fighting for their lives. And let us say that their role has an impact on vital issues such as the one at hand today. We would also like to invite this court to consider that the states should look to other modern legislations, Europe about AI, neuro rights, and other rights that have an impact on human rights in general. Principles such as ethics and transparency, principles such as human-centric development when it comes to any activity that has an impact on climate, on the climate crisis, and also explanations being offered and consequences being examined. All of this must be borne in mind in fighting climate change and this as an emergency. I thank this court for this opportunity.
I would like to thank the International Observatory for Human Rights and the National Bar Association of Mexico for your participation in this hearing. We will now begin with questions from the judges. Judge Patricia Perez Goldberg, do you have any questions? Yes, Madam President. Thank you very much for all of these interventions. They have been very illuminating. We don't have much time, and we have quite a few speakers, so I have just one question to ask to the representatives of the University of Notre Dame. I would like you to go into a bit more depth on two subjects. First of all, what the professor was saying, Professor Desierto, about measures that would make it possible to make the principle of effectiveness more specific, both under the Paris Agreements and all of the other relevant instruments on the subject in determining, and of course the Convention, for determining the contributions, the NDCs of each country. Perhaps you could go into that in a bit more depth, and also about the audits that you mentioned and how you would relate that initiative to the work being done by the San Salvador Working Group. Is there a connection? Would it be complementary? Would it be instead of? So this is a question for you. First, Professor Desierto, and then Urbina.
Thank you very much, Judge Perez. I would say, in the first place, that the approach is complementary to what is already being done. The necessity of having a mandatory audit at this point is because there are already existing NDCs and climate actions that states are implementing in a very variable way. And we don't know the degree to which they truly realize or fulfill the human rights obligations of these states, right alongside the goal of promoting or seeking carbon neutrality. A classic example of this is the United States' own NDC, which recommends that electric vehicles must be adopted. Not everybody has $75,000 to pay for an electric vehicle. For a lot of people, even looking at the batteries that are used in electric vehicles, there's a lot of child labor and mining and of the rare earths that go into that. But nobody is scrutinizing how these policy benchmarks are being put in the NDCs, which is why we've had to have national litigations, especially it was been effective in the Netherlands, in Urgenda, to force the government to justify its climate ambition right alongside its international human rights duties. Thank you, Judge.
Muchísimas gracias.
Thank you. Professor Urbina, in view of the shortness of time, I assume you didn't have time to talk about this, but in your written submission, you made reference to the analysis of the principle of proportionality. Perhaps you could talk about that. Thank you. Madam Judge, we did mention the principle of proportionality in discussing the effectiveness. The idea is not to go into a lengthy methodological debate. The academic literature is complex on the subject of proportionality, but the idea was to say that it's a very basic point. The idea that is shared by people who agree with that proportionality is critical, that it's not necessary to sacrifice one right in favor of another in general terms. There are various ways to meet the obligations that are part of fundamental rights. In some legal systems, for example, there are rights that are established in broad terms, but there are obligations that can easily be overruled in certain specific cases. In other legal systems, for example, rights are much more specific, much more limited. They're strongly asserted, but they are very limited. What we don't see happening and what is out of order would be to establish a priori obligations that overrule others, that displace others. So, especially in the terms of the principle of effectiveness, states have obligations from climate change and other obligations from human rights, and they are bound by both, and they need to know how to integrate the two. You can't sacrifice one in the interest of the other. Thank you for your question. Thank you. I have no further questions, ma'am.
Thank you, Judge Perez Goldberg. Judge Veronica Gomez. Thank you, Madam President. I first would like to ask the Dean Celorio. Dean Celorio referred to differentiated approaches. We've heard a lot about this in these past 2 days, and she referred to symbiosis between the Belén do Pará Convention and the American Convention, and Belén do Pará is well known within the inter-American system. We also have the big challenge of intersectionality, not just talking about gender. She also referred to indigenous peoples. UCLA is also referred to indigenous peoples. So how can we use what we have learned out of that symbiosis between these two treaties to extrapolate to other circumstances we have with less instruments and standards than what we have, just thinking about gender? Thank you, Judge Gomez, for your question. I actually believe it's one of the most important points where the court has much to contribute to the gender area, but not just gender, but also intersectional discrimination. In my opinion, this is one of the most important courts worldwide in anything related to gender. You have developed very broad standards that have a wide reach. They're very innovative and specific, and what is related to the duty to act with due diligence. And if we look at the line of standards by the court, you can find that symbiosis between the American Convention and Belén do Pará. So at the end of the day, I believe it is very important for the court to continue using those instruments and that interrelation among rights within those instruments. Now, I also believe that this situation offers content to those. So when we're talking about the climate emergency, we're talking about the duty to prevent, we're talking about violence and discrimination, but also specific measures that states should be adopting. And I believe that the American Convention and the Belén do Pará Convention give us a good framework for the court to provide examples to states, to tell states this can be an adaptation measure to address the disproportionate impact on women of the climate crisis. And when I talk about women, at least in this current time in history, we're already thinking about an intersectional approach. And again, this is one of the courts that has most developed this approach. It is admired, a very useful concept. And at this time, it would be very useful to give more specific content to climate change in that sense, and how states can address those specific risks for women in particular. But not just women, thinking about closed reading of the term. We're talking about indigenous women, women with disabilities, migrant women, displaced women, most of the ones that are most affected by the crisis. So again, a singular opportunity of continuing to interconnect these instruments and also interpret them in a living manner, in a very concrete manner. And I particularly mentioned adaptation, because many courts are already issuing pronouncements on mitigation, but not necessarily providing content to adaptation, and especially regarding vulnerable populations. And based on such a rich precedent as the Inter-American Court has, you have a unique opportunity to develop standards that can be followed worldwide regarding vulnerable populations and the specific concrete content of the measures. This court provides guidelines, provides directives. Your judgments on gender are so specific and detailed, and I believe that is something that gives you the space to truly contribute in a way that other courts are not necessarily in the position to do. Thank you very much. Thank you.
Professor Desierto? You have to talk more about the gap, sorry. I mean, I know you started with my colleague with her question, but I think it's one of the big topics. Huh? So if you could, you said your words were the gap that this court is the one that is in a position to address, you know, the gap between the non-binding voluntary declarations and the legal obligations. And everybody has been talking about all those doors that the Paris Agreement leaves open, but the feeling is that there is a stepping stone that is missing. So could you elaborate on that?
Thank you very much, Judge Gomez. I'm not asking the court to be forced to rewrite or reinterpret the Paris Agreement. We are asking the court to wield its jurisdiction to require that the states that have to submit these NDCs ensure that every single NDC, every target, every policy that they mention actually was constructed under a human rights approach that's consistent with the convention and thus draws on all the stakeholders who will be impacted by the policy choices of the state. And in implementing that ambition, implementing these climate actions, that the court, or rather that the state, will also be abiding and respecting and protecting the human rights of its own populations and populations under which they exercise some form of sovereign control or effective control, that they will continue to commit themselves to their obligations under the American Convention and the rest of international human rights law. Nobody has done that, Your Honor, because much as they included this paragraph in the Paris Agreement, none of the global north or the major emitting states wanted to enter into a discussion on human rights compliance with climate actions. There was always a constant deference to states can choose whatever modality they want to meet their climate ambition, so long as they don't retrogress. But what's left from the equation is whatever ambition they set, how does that impact the lived realities of the populations that have to deal with the choices that our governments are making today? It's for that reason, Your Honor, that we are appearing before this court, hopeful that this court will stand in defense of human rights here.
Sorry, I have to just follow up.
Yes, Your
On
Honor.
you, because you also said that this gap, in a way, is the reason why we have all these examples of strategic litigation worldwide.
Yes.
Because
Yes, Your
everybody's
Honor.
knocking on the door,
Yes, Your Honor.
trying to get individual decisions one by one, knocking door by door
Yes,
of the
Your
entire
Honor.
planet.
Yes, Your Honor, and frankly, it is very hard trying to litigate across individual jurisdictions when we do not have authoritative international law that says it ought to interpret the 12th paragraph of the preamble of the Paris Agreement, but no one is holding other states, fellow states, to account that your climate actions ought to be consistent with human rights. It was very difficult litigation in the Philippines carbon supermajors case in the Constitutional Commission on Human Rights, where finally there was an adjudication there that the carbon supermajors are responsible for the human rights consequences of their emissions. It was also very difficult in Urgenda, and also difficult in cases like Milieu Defensive versus Royal Dutch Shell. It's so incremental, Your Honor, that if there is no international decision that could authoritatively lay this down, and I am afraid that the International Court of Justice advisory opinion and the ITLOS advisory opinion are not touching the 12th paragraph of the preamble to the Paris Agreement. I am afraid that we are stuck with individual national litigation.
And with us. Okay.
Your Honor.
Dr. Urbina,
Dr. Urbina, you mentioned something, which is how to connect all this with political, civil rights, the classic rights. And you have given a task, a very particular task to the court. We don't have time, but this is a very major issue. The consequences of climate change will manifest in a way that they could trigger emergency situations. So if you could please clarify. Thank you, Judge, for the question. There's two things. One is the separation of powers, democratic institutionality, and the other is the suppression of guarantees. I will refer to both very briefly. As to democratic institutionality, the macro suggestion is to say the court and the inter-American system overall for a long time has richly developed democracy and institutional democratic institutions, so it's a leading system in that sense. So those developments should be incorporated, at least that is what we suggest, in this advisory opinion. And the reason for this is because the issue of climate change, given the complexity of the issue, sets forth institutional aspects, who decides, how they decide. So it fundamentally calls upon this, different from other human rights issues. It asks for very active participation of all the functions, all the powers of the state, and for all of them to operate in due form. So it requires legislation, very specifically. This is mentioned by the European Court on the Klimaseniorinnen, and in the decision it shows up and how the separation of powers, it's not necessarily something common in these matters, but it's just the complexity of the problem. Climate change first requires there to be legislation to articulate all these systemic regulations that affect so many different orders. In the previous session, we heard about electric vehicles, batteries, so coordinating many things throughout the country. And this can only be done through legislation. If not, you will have something missing. But then you need implementation by the executive branch, many technical capacities. If not, again, you will not have it all. And then you need access to justice. If any one of these pieces of the puzzle fails, it becomes very difficult to operate. So it is a great opportunity to remind states that the obligations, the human rights obligations that are related to climate change will affect all three public powers of the state. And it's a way of giving context to the institutional matters that are very much discussed, obviously because of climate change, such as access to justice. So it's all seen under the general context of the separation of powers. And as to the suspension of guarantees, our main concern there is just to preserve the statute of the suspension of guarantees as something used only in exceptional cases. It's a form it has always adopted. The risk, because we are using the term emergency in this context, and it is correctly used in a scientific civil society language, but because it is being used in this legal context, there is a risk for that concept to go out of the scientific sphere and to be interpreted legally. So you think it would be clearer to say climate crisis instead of using emergency in international human rights protection? I think it is legitimate to use the term that is used in specialized literature on climate change, but I do believe that if it is done, if you use the term emergency, it would be good to clarify that it is not being used in the technical sense of Article 27, and that the statute of suppression of guarantees is still an exceptional statute, and therefore there may be crises related to climate change that could trigger an emergency, as under Article 27, rightly so, but it's not the climate emergency we're living, because it's in the whole world at all times. So it should not be enough cause or just cause to lead us to suppress guarantees, because that would mean it would no longer be exceptional, and it is very important for it to remain exceptional. Thank you very much. No more questions.
Muchas gracias.
Thank you, Judge Gomez. Judge Ricardo Perez Manrique, do you have any questions? Yes, Madam President, I do. Please. Also, for the University of Notre Dame, I have a couple of questions for you. In your brief, you said that, or you warned about the risk of doing a proportionality analysis and that there be a simplistic balancing of the rights at stake. So my question is the following. What are then the lines of action that are necessary so as to not fall into that simplistic approach, according to you? Because there's a principle according to which all rights are indivisible and interdependent, and they're all, there is no hierarchy. So that's the question, why you're making that warning, which is so strong. No simplistic analysis. What's the trap that we could fall into, or what's the sin that we might commit?
Thank you very much. I'm sorry. Thank you very much, Judge Manrique. The trap is thinking that in trying to achieve the climate ambition, that there is only one pathway, and that pathway will always require a trade-off that sacrifices human rights. We heard earlier this morning, Judge Manrique, from the International Union for the Conservation of Nature, and how the science, even if it is the best available science, the global stocktake requires that we balance equity and the best available science, the capacities of the state involved, and we don't prescribe very specific goods, but rather recognize the right to self-determination, the right of the state to development, to choose its own path towards carbon neutrality that is consistent with the flourishing of human dignity of every single person within their jurisdiction. We are afraid, Excellency, because in jurisdictions that do not see the realities of poverty, where there is high inequality, where it is all too easy to opt for the easier electric vehicle sort of response, that governments or politicians will simply prescribe this good versus that good without inviting the public dialogue that considers the vulnerabilities, the differentiated vulnerabilities of populations that cannot adapt all in the same way to the climate crisis. So we hope, Excellency, that this part of our brief is intended to call out that precise danger. We're already seeing national litigation taking place, questioning the rapid mitigation, allegedly rapid mitigation measures that are supposed to achieve the climate ambition, but in the end will give a pass to the biggest emitters and impose the burdens on those who cannot afford it.
I understand, but at the end of the day, in every policy, be it one for equality or mitigation, there should be a balance struck amongst all rights. That's a principle in the end that has been established by the court throughout its jurisprudence. So we take note of that warning, but we will act as we usually do. My second question, something of concern to me. Yesterday, Professor, I heard you, and you just said again, I heard you before, and you just said again, and I would like for you to please rectify this if I misunderstood, that there is a very comprehensive regulatory corpus in terms of climate change. So there are different regulations that about this, but reality is showing us that above and beyond the existence of these regulations and rules, the major players, the major emitters, pollutants say, these are but recommendations, they're non-binding, right? So do we have a corpus juris that is just soft law? So what about that corpus juris? As I said, the large players, the big players, believe that they're under no obligation.
Sorry.
Perdón, y le agrego para...
And if I may add, can you hear me?
little bit, Your Honor. I'm sorry, Your Honor. If I understood the question correctly, the question pertained to whether or not there is jurisprudence that could potentially restrain the largest emitting states. And this is something that beleaguers the entire international civil society movement, precisely how to hold the biggest emitters to account. The International Tribunal on the Law of the Sea, which is set to issue its advisory opinion this May 21st, was the first to receive the public written statements of the European Union, Germany, the Netherlands, China. It did not receive a statement from the United States, which is not a party to the Convention on the Law of the Sea. Those written statements present a range of views, some of which accept that there are binding commitments under the UNFCCC and the decisions of the Conference of Parties that push, especially in the global stocktake decisions, that already require certain measures to be taken on mitigation in order to avoid further escalation of the crisis. But we do not have a settled decision on this subject yet. There was an attempt in the Supreme Court of the United States, at least in a case called West Virginia versus EPA. The Environmental Protection Agency in the United States tried to itself, as an administrative agency, force the shift from electric use to renewables. The Supreme Court said an administrative agency can't do that. We have to wait for Congress to pass it. So, lacking an international decision that itself could be a subsidiary means of determining international law, I'm afraid we are left to the mercies of the uncertainties of national and regional litigation, Your Honor.
Está claro. Yo no.
That's clear. I am not concerned about the jurisprudence of countries in this sense. What you are telling the court is that it should take a step forward and establish certain obligations for the states about when making their projections about carbon emissions and NDCs to include human rights and bear them in mind. So we are an inter-American court interpreting the American Convention on Human Rights. In the terms of the American Convention of Human Rights, what is your proposal to this court? Because you've made a general proposal, which I agree with, I'm sharing here, but so under the American Convention, how do we solve this issue, which is at the end of the day what we have to do under this advisory opinion?
Very much, Judge. I agree, and we certainly do not request the court to try to extend or overreach, but we also do not want the court to underestimate the significance of its advisory opinions as a source of international law, as a subsidiary source of international law. Certainly, we cannot tell states parties to the Paris Agreement that every single climate action has to follow a certain path of justification under human rights law, because all that we have is the language from the 12th paragraph of the preamble of the Paris Agreement, and that is not the governing instrument for the court. But we could do it the other way around, Your Honor. The states themselves could be obligated in assessing their existing commitments in the NDCs to test them against their adequacy or inadequacy as against realizing the rights that have been safeguarded under the American Convention and the jurisprudence of this court, including most especially economic, social, cultural rights that this court has been responsible for developing and in progressively realizing for the American system. In the same token, we also don't expect that the rest of the world will suddenly do the same thing. But there might be a jurisdiction, Your Honor, that says, but this is an advisory opinion of the Inter-American Court. It's a source, a subsidiary source of international law. This might provoke the pathway for how to ensure that human rights is no longer at the periphery of the climate regulatory system, but instead is at the heart of it. The whole discussion of vulnerability that we had in the Intergovernmental Panel, the 6th assessment of the IPCC, focused on all vulnerabilities, but completely forgot that these vulnerabilities are structurally created from human rights deprivations, Your Honor. And that is a voice that this court could very readily educate the rest of the world on, and hopefully all the other courts in the international system. Thank you, Your Honor.
Thank you very much for your answers. I have no further questions.
Thank you, Judge Perez Manrique. Judge Eduardo Ferrer McGregor, do you have any questions? Thank you, Madam President. I do have a question for CEJIL. You mentioned, Professor Rosa Celorio mentioned the case of Daniel Billy et al. V. Australia, and that in the Human Rights Committee, and the committee in this case did not hold that there was a violation of the right to life. It did grant Australia the argument that the damage was too far into the future and too ill-defined to determine, and I quote, a foreseeable risk of being exposed to physical risks and extreme precariousness that could threaten her life, her right to life. So the question, it's because you raised this case, what do you think? What is your opinion in light of the precedents and for the inter-American system? Thank you, Your Honor. Yes, the case of Billy is especially interest and very dichotomous because it is very vigorous in the area of indigenous peoples and means of adaptation. The committee found that there was a violation of Article 7 and 27 of the Covenant on Civil and Political Rights, with a great deal of emphasis on the threat made up of everything that was happening with people living in Torres Straits because of rising sea levels, flooding, the lack of measures of adaptation, even though they had advised the state on multiple occasions that they needed such measures. Much of the subject that I find so interesting from the standpoint of a court that is about to issue an advisory opinion is that this is one of the very few cases available that has specific examples about adaptation specifically for indigenous peoples. So this is what we want to focus on. I think that this part, especially the analysis of how the climate emergency and the failure of the state to respond interferes as an exercise of culture, as an exercise of the right to private family life, for example. Now, what I do think that the court can do, the Inter-American Court can do, and where it can make a much more significant contribution is in the right to life and right to a decent life. And now you have a line of case law on the subject. You did it in Arroyo very recently. I think this is a court that is very well positioned to draw the link between the right to life, the right to a decent life, draw a link from that to the climate emergency and to this situation of groups that are disproportionately affected. And the IPPC has said this. The indigenous people have said this. So you would draw a connecting line between these rights, such as right to culture, private family life, and also to the right to a decent life. And the Inter-American Court already has precedents in this area. And in fact, the right to a decent life began with the Paraguayan cases on indigenous peoples. So I think that the Inter-American Court is even better positioned than the Human Rights Committee to build these bridges, to connect these subjects, and to give content to the idea of a decent life, and also to explain and to develop this argument connecting due diligence. We've already talked about that in 1.1 and 1.2, such as the right to life as a basis, and how this right to life is so intimately connected to these other specialized measures that need to be taken by the states for mitigation and adaptation to climate change. In my view, then, it is a significant case, but it's also extremely valuable with respect to indigenous peoples, the value of culture, and something else. And I apologize if I'm going too far on this, but I do think that one of the most important things this court has done with its which is case law indigenous peoples, is that you talk about individual and collective rights. This is one of the only courts in the world doing that, and it's an excellent opportunity, a significant opportunity to talk about the right to a decent life, and to think about what this means at the individual and collective level in the presence of a climate emergency and communities that are saying this climate emergency has created many barriers preventing us from gaining access to our territories and our culture, and what this means for the whole collective. That is, it's not just interruption of their life plans, but also for the communities, so the future of the communities themselves. And this is something that the Inter-American Court has seen. And just one more thing, just to close, the Human Rights Committee, in its general comment 36, did develop the idea of a decent life. And this is fascinating about the case, which is that ultimately they did not develop it in this case, but in the comment they did. This comment by the Human Rights Committee, and it's a very important comment, number 36, and it does draw the link, decent life to climate. So the committee has already done it. They've drawn the link, they've drawn the connection, but not necessarily with a specific case. But this is something the court can do. Thank you very much for your question, Your Honor. Thank you. This is a multi-tiered dialogue, isn't it, with the whole context. So I thank you. For the International Network of Civil Liberties, with respect to standing, we're talking about dialogues, and recently the European Court heard some cases, some of them having to do with standing per se, but in the end they weren't able to get to justice because of that. What can you say comparatively about the inter-American system? This also has to do with access to justice.
Gracias, señor juez.
Thank you, Your Honor.
The European Court of Human Rights was extremely restrictive in its approaches to standing, and as I said in Klima Seniorinin, the case that deals with standing, and especially of standing of individuals, it was interpreted in a way precisely to avoid further cases being brought because the bar was put too high. And even with regard to NGOs, and the association was the only applicant in that case which was found to be a victim of violation of the European Convention, again, the interpretation was very strictly limited, so that only like climate oriented organizations, but for example not the associations of indigenous peoples, may bring complaints under the European Convention. These are the examples precisely not to follow unless you want governments to escape scrutiny. And the difference is that under the American Convention, of course, the issue of standing, the very provisions of the American Convention are much wider, and the most recent case of La Oroya shows that the shift from the need to prove causal link, which is impossible, but which was in the advisory opinion 23, to a more workable test of exposure and risks to human health are precisely the way to proceed to adopt standing issues to climate change complaints.
Muchas gracias.
Thank you very much. No further questions.
Judge Vice President Rodrigo Murovich, would you like to ask questions? No, Madam Judge. Thank you. I do have a question for ICLA. You've again brought to the table the issue of consultation for indigenous peoples. I would appreciate you to give some more information on the scope of the impact, whether the impacts are limited to the territory. Whether impacts are limited to the territory. Thank you, Madam President, for the question. I will answer in Spanish. It is not limited to the territory. The consultation and the right to free, prior, informed consent is a safeguard of substantive rights of indigenous peoples, including, but not limited to, the right to territory, land, and resources. It also includes the right to free self-determination, the right to culture. But I was referring to the climate impact. The climate impact. Oh, okay. When we suggest that the court should reinforce protection for the right of free self-determination, that is one of the fundamental rights of the indigenous peoples that is related to climate change. I alluded to this when I mentioned that self-determination of the peoples and their strengthening and empowerment does not just result in benefits for indigenous peoples, but for the whole of society. So it implies that peoples can collaborate and cooperate with the protection of the environment as equal partners, the same as other states, citizens, peoples. Additionally, as to free self-determination, it could lead to new relationships with indigenous peoples, where their knowledge is also part of the dialogue, it is part of the international dialogue, to see whether we may change the paradigm in the way we are facing the climate crisis. So, consultation and free, prior, and informed consent are closely linked, not just to the territory, but with the self-determination, which is also closely related to the way we face the climate emergency. That would be one way of putting it. Thank you for your answer. To the International Observatory of Human Rights, as you well know, this court has been requested to build up the concept of epistemic justice. So I would appreciate to know how we can incorporate ancestral, traditional, indigenous knowledge in the elements of science, both concepts that you have mentioned in your submission. Thank you, Madam President. What we have proposed and interpreted is that the way to integrate this is precisely by understanding the implications, the risks, and the communication channels that the state should have through its relevant bodies with indigenous peoples, so that they may provide feedback and give their voice and perspective, and based on that, considering it along with the rest of the information, so states may adopt policies and standards that can protect their human rights against the impact of this emergency. Thank you very much. And lastly, for CEJIL, I'd like to know if you could give more detail as to the concept of significant damage that you have mentioned in your submission. Thank you very much, Madam President. This court, in the case of La Oroya, has actually related the significant damage, and where you can find these types of damages when they are related to violations of the right to life or personal integrity. And we assess significant damage related to the risk theory that the court has also developed. The significant risk that the court has also brought in cases of Nicaragua versus Costa Rica is fundamental to provide consistency to how we may determine the type of damage related to the climate emergency. So the risk of a significant harm or damage is whether it is foreseeable or a created risk, that again is something that has to be determined on a case-by-case basis, is fundamental to provide content to the enforced or enhanced due diligence obligations. Thank you very much, and with that we close this segment. Thank you all for your participation and contributions. We will break and reconvene at 5:10, 10 minutes past 5 for the final session of the day. Thank you. Please rise for the court.
Good afternoon to one and all. This public hearing is called to order. We will now have the fourth part of the second day of hearings. We would like to welcome all participants this afternoon, and we would like to thank you for being here today. I will now recognize the registrar to issue the necessary instructions. Thank you, Madam President. Please speak slowly and clearly to facilitate the work of the interpreters, and please identify yourselves when you take the floor. Thank you. According to the order agreed on for today, next in line is ClientEarth. You have the floor.
Madam President, distinguished members of the court, it is an honor to appear before you on behalf of ClientEarth. My name is Lea Mein-Klingst, and I'm a lawyer in our fundamental rights team. Due to our role as counsel in the UN Human Rights Committee case of Billy and others v. Australia, I will spend some time today highlighting elements of that case we consider relevant to these proceedings, specifically on the rights of indigenous communities and the effectiveness of required state measures. My colleague Sophie Marjanak will then address you on the duty to regulate businesses under human rights law. In the Billy case, 8 indigenous individuals from the low-lying Torres Strait Islands in the Australian state of Queensland, called Zenit-Kes in the local language, which you can now see on your screen, asked the committee to apply the International Covenant on Civil and Political Rights to climate change impacts such as rising sea levels, coral bleaching, biodiversity loss, flooding of their homes and burial sites, and seawater contamination of their agricultural lands, affecting their livelihoods and culture, threatening their very survival. On the screen, you can now see evidence submitted to the committee. This photo was taken in March 2019 on Boigu Island in the northern Torres Strait. Boigu Island is between 1 and 3 meters above sea level. The photo shows the impacts of the king tide, the highest tide of the year, which, as you can see, floods the whole island. These tides are getting worse every year. The islanders submitted evidence demonstrating how the effects of climate change impacted their right to private and family life and their right to culture. All these are inextricably linked to their traditional land and sea territories. And I quote, "We have a right to practice our culture and to practice it here, in our traditional homeland where we belong. Our culture has a value to us that no money could ever compensate for. Our culture starts here on the land. It is how we are connected with the land and the sea. You wash away the land, and it is like a piece of us you are taking away from us." Much of the legal analysis that underpinned this evidence relied heavily on this honorable court's jurisprudence. Ultimately, the UN Committee found that the state's failure to adopt timely and adequate adaptation measures violated the islanders' right to private and family life, as their access to marine resources, fruits, and crops was drastically reduced, and the flooding of the islands entailed flooding of ancestral burial sites and traditional gardens. All of these caused anxiety and distress. Similarly, the committee found a violation of Article 27, which protects the group's, and I quote, "collective ability to maintain their traditional way of life, to transmit to their children and future generations their culture and traditions and use of land and sea resources," end quote. These findings make clear that the right to culture includes the right to maintain such culture for future generations. On the basis of the right to an effective remedy, the UN Committee obliged the state to 1. Provide adequate compensation to the claimants for the harm they suffered, 2. Engage in meaningful consultations with the claimants' communities in order to conduct needs assessments, 3. Continue its implementation of measures necessary to secure the community's continued safe existence on their respective lands, 4. Monitor and review the effectiveness of the measures implemented and resolve any deficiencies as soon as practicable, and 5. Take steps to prevent similar violations in the future. This marked the first time a human rights body ordered compensation for climate change harms. The Billy decision also clarified that under human rights law, states' adaptation and mitigation measures are both open to judicial scrutiny. Just recently, this was reaffirmed by the European Court of Human Rights as the court undertook an analysis of a state's mitigation measures to determine whether it was in compliance with its human rights obligations. At paragraph 550 of its Klima Seniorinnen judgment, the European Court set out the minimum standards of what states are required to do to comply with their positive obligations and how courts may assess the content of state measures, specifically requiring European states to set a national carbon budget derived from the 1.5 degree global temperature limit. Both the UN Committee and the European Court also reaffirmed that state measures must be effective in practice. As we argued in our written submission to you, such adaptation and mitigation measures can only be effective where they are not undermined by false technological solutions. You have heard and will have read much about the necessity of deep and rapid decarbonization. It is our position that where mitigation action is delayed in favor of unproven, unavailable, unfeasible, or simply false technological solutions, such action runs counter to human rights law, considerations of the best available science, and the precautionary principle. At the same time, the effects of such technologies on and risks to ecosystems and humans are not yet well researched or understood. Simply put, deep and rapid decarbonization cannot be delayed. The requirement that measures be effective also mandates that states regulate businesses due to their significant contributions to and role in addressing climate change. At this point, I will hand over to my colleague Sophie Marjanak and thank you for your consideration.
Good afternoon, Madam President and honourable judges. My name is Sophie Marjanak, and I'm a senior lawyer and the Accountable Corporations lead at ClientEarth. My brief presentation will focus on how human rights protected by the Convention are affected by corporate activities and the consequent state duty to regulate third parties, accepted by this court in its 2017 advisory opinion. I will set out specifically what we say must be the content of the state duty to regulate the emissions of businesses that fall within their jurisdiction or effective control.
The scientific evidence establishes a clear need for the phasing out of fossil fuel energy products. The majority of emissions caused or contributed to by fossil fuel producing companies occur after the sale and use of their products, that is, in the downstream part of the value chain. These are called Scope 3 emissions under the Greenhouse Gas Protocol, which is the global accounting standard and from which the diagram shown on your screen is drawn. For the world's largest fossil fuel companies, Scope 3 emissions are between 70 to 95% of their total footprint. The UN Guiding Principles on Business and Human Rights set out the obligations of states to regulate business enterprises, with Pillar 1 requiring states to adopt effective policies, legislation, and regulations to provide redress, even where business activities are not prohibited in international law. The UN Working Group on Business and Human Rights is the body mandated to promote compliance with the guiding principles. In 2023, it issued an information note on climate change, which stated that in order to comply with the guiding principles, states must enact climate change due diligence laws that cover the entire value chain. In August of 2023, the working group also sent letters following a ClientEarth complaint to Saudi Arabia, the national oil company Saudi Aramco, and several of its banks, requesting information on how each actor had complied with its duties under the principles to limit the human rights impacts of climate change. Applying guiding principle number 4, they said that for states controlling oil companies, states should take additional steps to protect against the human rights abuses by business enterprises that are owned or controlled by the state or that receive substantial support and services from state agencies. Globally, many companies have now voluntarily adopted emission reduction targets and claim to be aligned with or supportive of the goals of the Paris Agreement, and these are often set out in corporate transition plans. There is now a clear movement in Europe, which is expected to spread to other jurisdictions globally, to move towards mandatory transition plan disclosure and implementation. Relevantly, the EU recently enacted the Corporate Sustainability Due Diligence Directive, which provides in Article 15 for all large companies operating in the EU to adopt and put into effect a transition plan for climate change mitigation, which aims to ensure, through best efforts, that the business model and strategy of the company are compatible with the transition to a sustainable economy and with limiting global warming to 1.5 degrees. The article then goes on to specify in quite a lot of detail what the transition plan should contain, including Scope 1 to 3 greenhouse gas emission reduction targets out to 2050, a description of how the business's strategy will change and how the plan will be funded. The CSDDD covers a wide range of human rights and environmental impacts, and its main objective is to codify the business responsibility to respect human rights contained in Pillar 2 of the UNGPs. It also provides that compliance with Article 15 meets the due diligence obligations in respect of climate change, meaning that companies must have a transition plan that contains reduction targets for Scopes 1 to 3 emissions. We submit that this demonstrates that reducing emissions rapidly across all parts of a business is required to comply with corporate human rights responsibilities in respect of climate change. Although the Scope 3 emissions of many companies may be emitted to the atmosphere outside a state's borders, there is no issue of extraterritoriality or jurisdiction that arises, as states are required to regulate emissions that may occur outside their borders under human rights law. This was recently confirmed by the European Court of Human Rights in the Klima Signorinen decision. The applicants led evidence that included analysis of emissions created in the production of products that were finally consumed in Switzerland. This was disputed by the state, who claimed that it could not be held responsible for emissions outside its borders, and that considering these embedded emissions would violate the principle of territoriality. The European Court rejected the state's submission, finding that as the claimants were clearly within Switzerland, the issue was not jurisdiction, but rather attribution of acts or emissions to the state, and Switzerland's responsibility for the effects of these embedded emissions on human rights. The court said, it would be difficult, if not impossible, to discuss Switzerland's responsibility for the effects of its emissions on the applicant's rights without taking into account the emissions generated through the import of goods and their consumption. We submit that this court should find, and based on its previous jurisprudence, should find by analogy that the fundamental United Nations value chain principle applies, in particular to exported emissions or Scope 3 emissions that are generated by companies domiciled in a state and hence under their control, in respect of emissions from the extraction of fossil fuels within the state's territory that are sold onto the global market and therefore within the state's effective control, and financed by the state or by financial institutions domiciled within the state. Such a finding would close a significant loophole in international climate change law and confirm that states are responsible under international human rights law for their acts and emissions which facilitate the sale of fossil fuels on the global market. Such a finding is also necessary to ensure that state measures are capable of being effective, as noted by the European Court. This position would be aligned with Recommendation 2 of the UN Secretary-General's High-Level Expert Group report called Integrity Matters. It would also be aligned with the findings of the Committee on the Rights of the Child in Sachi in Argentina, which has been referred to in several other presentations. For too long, states have been allowed to hide behind...
Representante, se ha acabado su tiempo, tiene un minuto para concluir.
You have 1 minute left.
In there.
No, you can.
You have 1 minute to conclude.
For too long, states have been allowed to hide behind the fiction that exported and financed emissions are outside of their control, despite the well-known and acknowledged foreseeability of the harm that they will cause to people within and outside their borders. A clear finding from the Court on this issue would significantly enhance the protection of human rights from the devastating impacts of climate change. Thank you.
Muchas gracias a la representación de ClientEarth.
Thank you, ClientEarth. We now recognize the representatives of the Inter-American Association for the Defense of the Environment, the Foundation for Due Process, the European Center for Constitutional and Human Rights, FIAN International, Forest Peoples Program, the Legal Defense Institute, Jackie Dugard, the Minority Rights Group International, the Project for Economic, Social, and Cultural Rights, and Open Society Justice Initiative. Please proceed. Good afternoon, Madam President, ladies and gentlemen of the Court, and others. My name is Ana Elisa Samayoa from the Foundation for Due Process, and I will submit I'm here to discuss the written submission for members of the International Network for Economic, Social, and Cultural Rights, Red Desk, which brings together more than 280 NGOs, social movements, and activists from 75 countries. My presentation will focus on the extraterritorial obligations of the states in the context of climate change, the importance of fair, equitable energy transition, corporate capture, and access to justice. A number of speakers have already noted that climate change is a phenomenon that knows no borders and affects some states disproportionately. This means that the extraterritorial obligations need to be strengthened for regulating and monitoring companies whose activities cause climate damage. Because the conduct of a state can produce foreseeable adverse effects on the human rights outside its territory, inter-American case law and that of other supranational bodies excludes the definition of merely territorial jurisdiction. This means that both host countries of a transnational company and transnational companies must implement obligations to respect and guarantee the rights of the Convention. The Court has taken significant steps in this regard. In OC 223, it set forth principles and rules on the obligations of countries of origin of companies that commit environmental damage overseas, saying that the states have the duty to prevent cross-border environmental damage that can undermine the rights of people outside its territory. The Commission, in turn, has examined the obligations of both of host countries and countries of origin to adapt their laws and policies to prevent, mitigate, and provide mechanisms for access to justice, in emphasizing the obligation to implement a suitable regulatory framework to protect rights. We feel that this request for an advisory opinion is an opportunity to give feet to these standards for alleged environmental damages in general and situations of climate damage. Under current international standards, the states have a jurisdictional foundation when they are able to influence the actions of companies domiciled or registered within their territory by means of their investments or activities of their branch offices that cause climate damage. Given the capacity of the states to regulate and monitor activities causing HGH emissions, they can adopt policies to refrain from causing climate damage and adopt legal frameworks in this regard. The duty to prevent is applicable particularly for business activities that cause foreseeable and significant climate damage. This obligation could be fulfilled, for example, by requiring a specific analysis of the impact on climate change in environmental impact studies for a particular activity. Before concessions are granted, to make measures such as this, the states must adopt and enforce laws, regulations, and policies that encourage and require companies, through regulation, monitoring, and supervision, to reduce their emissions and prevent negative consequences for human rights, and to provide judicial and extrajudicial mechanisms for accountability for these companies. The states must also ensure that companies that have contributed to climate damage develop or participate in mechanisms for effective complaints, for effective grievances that can correct damage and satisfy the concerns of the people affected. In order to meet the commitments of the Paris Agreements, the states must adopt clear measures to achieve a fair, equitable energy transition. And this fair, equitable transition must not generate additional violations of the human rights or discriminatory practices against groups that have historically lived at disadvantage, and especially those that are vulnerable to climate change. These groups must be considered, must be taken into account, considering the impact of climate policies and actions from a gender and intersectional perspective. They must be cross-cutting in the way that they are developed and adopted. A fair, equitable energy transition means the states must refrain from enacting or supporting unrealistic solutions with no scientific evidence. I am referring in particular to the so-called nature-based solutions that have been included as part of the contributions at the national level of industrialized countries that have a high carbon footprint. Research on climate commitment of fuel companies have concluded that many efforts to offset CO2 emissions are channeled through organizations that have very little environmental integrity, and measures have in fact been damaging to indigenous peoples and vulnerable communities. An example of this type of offset is the so-called nature-based solution for so-called carbon credits. In general, the countries of the region do not have regulatory frameworks for certifying and trading these credits, which end up being negotiated in a voluntary market regulated by private certifiers. These credits have a degree of liquidity comparable to conventional financial assets that are covered by private contracts with clauses for confidentiality, which often violate the right of access to information or transparency in managing environmental affairs, as was discussed in the Escazú Agreement. Very often, these nature-based solutions replicate colonial practices of traditional extraction that pose the need for true solutions that respect human rights and are not implemented by polluting companies and their countries of origin. This reality is a reflection of corporate capture of policies and programs for containing the climate crisis that benefits the companies responsible for the accumulation of greenhouse gases in the atmosphere at the expense of the rights of people and collectives that did not contribute to the crisis. States have the obligation to prevent corporate capture in processes in decision-making process for climate change, ensuring that companies provide due diligence for human rights. Many countries, especially in Europe, have adopted or are about to adopt laws for due diligence on the subject. But in the context of corporate capture, a number of laws and regulations that have been enacted or are about to be or are still under deliberation do not provide effective mechanisms for accountability by corporations in the face of climate damage. Finally, I would like to talk about access to justice, derived from the difficulties triggered by climate change and the response on human rights, people and communities have turned to domestic and international courts so that governments and, to a lesser extent, companies would answer for the damage they have caused based on present and future climate damage. Standards developed by the Inter-American System and other supranational organizations do provide answers to situations involving judicial disputes about the climate, but most of the rules and legal principles are being developed in climate litigation in domestic courts. Among the rules and principles that have been established by the courts of various countries, and that we think that could be included in the current advisory opinion, would be, first of all, joining the Paris Agreement or other multilateral commitments for fighting climate change as human rights and giving them the status of human rights treaties, using the Escazú Agreement as an instrument for interpretation and the minimum standard on access to information and transparency for governance in climate policy, banning a return in the NDCs, a regression in the NDCs in light of the clause of non-regressiveness in Article 26, judicial review of the goals for reducing greenhouse gases and minimum parameters of guarantee and judicial protection to demand this. And finally, requirements for environmental impact studies should include an evaluation of climate impact. This advisory opinion could also clear up a number of questions about admissibility and adjudication in inter-American climate litigation, including application of the precautionary and prevention principles when evaluating requests to suspend state decisions that could cause climate damage. Next, use of the dynamic burden of proof for climate damage, especially when there is an imbalance between the alleged victims and state or private entities. Creating more flexibility in the legitimate procedural interest as a requirement for admissibility of a climate judicial action, which often means exempting the complainants from demonstrating damage to themselves. The status of victims faced with the allegation of climate damage that has not taken place, which can be predictable. The scope of judicial due diligence, including application of science to the attribution and other forms of producing evidence at the time of justifying the cause and effects, the cause and effect relationship between the economic activity and the damage. Even though the scope of the advisory opinion will not allow the court to anticipate all possible procedural matters applicable to climate litigation, we think that setting certain general parameters would provide an excellent roadmap, which would be invaluable for litigants, justice operators, at the court, and the commission, that is to say, future disputes. Thank you for your time.
Thank you for your contributions and the organizations you represent. I now give the floor to representatives of the Institute for Governance and Sustainable Development. Please proceed.
Thank you, Madam President, and Honorable Court. My name is Professor Durwood Zelke with the Institute for Governance and Sustainable Development. The Institute is a think tank that works with the world's leading scientists to understand climate change and turn that understanding into effective and enforceable law and policy. I'll address the pivotal facts of the climate emergency, which can be distilled into three basic concepts: temperature, tipping points, and time. It's too hot today, we're too close to tipping points, and we have too little time left to slow warming. Today's 1.2 degrees of warming is not safe. Climate impacts are already causing human rights violations in the Americas and around the world, and every tenth of a degree that follows 1.2 will expose 140 million more people to extreme heat. Now, if we were able to stop here, we might have a chance of adapting to climate impacts. But we're not stopping. Emissions are continuing, warming is accelerating, and we're on course to crash through the 1.5 guardrail of the Paris Agreement by 2030, maybe a couple of years after. And we'll crash through the 2-degree barrier by 2050. Now, it's critical to keep warming below 1.5 because between 1.5 and 2 degrees, we face 11 irreversible and catastrophic tipping points. That's between 2030 and 2050, 11 tipping points. We're going to lock them in. 3 specific examples. The Arctic sea ice. We've lost half of that great white shield. When we lose the second half, it will add the equivalent of 25 years worth of current emissions. That will further collapse permafrost. That will release methane and CO2. That will set off self-amplifying feedbacks that cause still more warming. The Amazon is another tipping point. A little more warming, a little more destruction, and we turn the forest from a sink that pulls CO2 out of the atmosphere into a source, another self-amplifying feedback. The Greenland ice sheet is another example of a tipping point. The best available science says when we hit 1.6 degrees of warming, we will lock in the collapse of the Greenland ice sheet, and that will contribute 5 to 7 meters of sea level rise around the world. These tipping points and the rest of them will cause massive human rights violations. They'll be irreversible and they'll be catastrophic. But this doesn't have to be our future. The scientific assessment panel of the CCAC yesterday told us that if we cut the short-lived superpollutants, we can avoid 0.6 degrees of future warming by 2050. That is many times more than just decarbonizing the energy system. Cutting methane alone can avoid 0.3 degrees Celsius, and it's the biggest and fastest way to slow warming in the near term. We need to turn the methane blowtorch off as soon as possible. We can start with the oil and gas industry as we phase out that industry. We can enforce the promises that they made at the last climate meeting in Dubai, where more than 50 national oil companies said, we will stop our leaks of methane and we will stop flaring by 2030. That's a great promise. Now it needs to be turned into a mandatory obligation. To conclude, we must win 2 races. The first is a sprint to cut the short-lived superclimate pollutants in the near term. The second is the marathon to decarbonize the energy system. We have to do both. Neither one alone will keep the planet safe. These are described in the IPCC's 2018 1.5 special report. It was good advice then, it's good advice today for the world and for this court. Thank you.
Buenas tardes.
Good afternoon, Your Honors.
Romina Piccolotti. Good afternoon, Court. I am also part of this presentation. I am in the Ministry of Sustainable Energy in Argentina, and I have also participated in climate change negotiations with all the rest staff developing countries, basically. The facts the Honorable Court has heard over these 2 days and that have been highlighted by Professor Selke have legal consequences for human rights. To be brief, beyond what we have submitted in our amicus, there are 2 key legal consequences that we should highlight. First, it's a substantive it has a substantive nature, and the second is more procedural in nature. The first is acknowledging resilience as the condition for states to be able to abide by their obligations of preventing and protecting under the Convention. Therefore, along with Professor Dinah Shelton, we have worked on the human right to resilience. The human right to resilience as a standalone right, or as Professor Shelton holds, as part of the interpretation of the right to life. There's two implications for states. The first obligation is to mitigate in the short term, so reduce the rate of warming in the short term and remaining under 1.5 degrees. The second obligation is an obligation to adapt, which is basically investing in the most vulnerable groups so they may be resilient in the face of climate change and its impacts that we already see at 1.2 degrees. Science helps us even more in identifying the content of the obligation to mitigate, as we heard from Mr. Zelke and those before us. For mitigation to be effective in the short term and to help us gain time to build resilience has to focus on mitigating short-lived pollutants, especially methane, that has 82 times more capacity for warming. It's also important to point out that the IPCC, that all states have agreed to its conclusions. It points out that the higher temperature, the less effective adaptation measures are. So adaptation has a limit. And therefore, we believe that the human right to resilience effectively brings together the obligation to adapt and the obligation to mitigate. The second legal consequence is procedural in nature. Young people today, the young women we heard this morning, and NGOs have expressed the need for access to justice. This court, very wisely in Loroya, gave a very important step in terms of active legitimacy and standing for future proceedings. But we also must understand, as we heard from Professor Zelke, that the dimension of harm in climate and the dimension of time is absolutely different from what traditional law is used to. We're talking about harm and damage that is not extraordinary, and a time that, although the actions we have today, that the actions we take today will have consequences for future generations, hundreds of years from today. So the challenge for the judiciary in all the region and to access to justice in the region, and this challenge might be reflected in the advisory opinion, which is to adapt legal emergency procedures so that they may reflect this dimension of harm and urgency. If we use precautionary measures and others, the ones requesting those measures have to prove the damage and the urgency. We suggest to the court that, considering the fact that this is an emergency and the damage that have been widely proven, to reverse the burden of proof, whether the precautionary measure entails measures against a private company or the state. And another very concrete measure that has been put forth by the court in Loroya is training the judiciary. We believe it is essential for constitutional courts that will be hearing these types of cases to be trained continuously regarding the climate emergency and the short-lived pollutants. You have 1 minute to close. Yes, to close, and we close in solidarity with the court.
Thank you to the Institute for Governance and Sustainable Development for their presentation. Next, we will hear from Earth Rights Advocacy, based at the Center for Human Rights and Global Justice with the New York University School of Law. Thank you, Madam President and honorable judges and members of the audience. I'm Cesar Rodriguez Garavito. I'm a professor at the Law School of NYU. For me and my colleague, Professor Medina de Bona, it's an honor to address you on behalf of our institution. I would like to start with a face, The image you see here is that of an indigenous leader, Sheila Watutier. She is the leader of an Inuit Alaskan people that initiated legal action on human rights and climate change. And this was this was decided upon in 2006. So the Inter-American system has had a major place in the development of this corpus juris. This was a 20-year process that led to the creation of a corpus juris comprising 312 cases specifically on human rights violations related to climate change, and whose most recent example is the case that has been mentioned once and again of the European Court of Human Rights, Klimasignorinen versus Switzerland. Our presentation is based on the analysis of a database of all those 312 cases, which is compiled and updated on an ongoing basis by our institution. We would like to provide the website address for the court together with a book including its results. In the interest of time, we will only focus on one feature of climate change and show that it gives rise to specific and special obligations that supplement those that have been established by the court in OC 23 and in environmental cases such as that of La Oroja. And I'm referring to the time variable in climate change. Global warming does not evolve in a straight line. It speeds up with time and becomes even worse because with every 10th of degree, irreversible damages can happen, such as turning the Amazon into a savanna, an arid savanna. This may lead to a cascade effect that will lead to more qualitative damages in the climate system and that will have a knock-on effect on human and non-human beings. Climate is not a change, it's an emergency. And that is why a time component must be added to the state's obligations and that of businesses in relation to climate change. That essential component is a sense of urgency. It's not the same to act now as it is to act in 5 years, 10 or 20 years from now. The problem now is not climate denial, because there are no authorized voices that deny it, but rather delay tactics and denying the imminence of the problem. Honorable Court, this delay and these lags have had major consequences and have led to a lag that must be compensated for as a matter of urgency. Last year was a record as the hottest year in history. This chart, where the red line shows the accelerated increase in temperature, reveals a situation that brings us close to the edge, a point of no return over the last 20 years. The last 20 years that have consolidated the comparative jurisprudence that we are referring to, states have been far from resolving the climate emergency. The lag is even more dire because during that time, and at least since the beginning of the 1990s, states have been aware of the phenomenon of climate change and the need to act in the face of climate change. So the task of the human rights system is to make up for lost time and do so as a matter of urgency. This has been the message sent by several courts around the world in decisions about climate-related cases based on the law. Since 2015, when groundbreaking decisions were emerging linking climate change to human rights, a case against Pakistan had already established it. In this case, which is cited as one that is based on the rights from the Global South, the Court of Lahore found that the lethargy and the delay of the state in acting has had violated rights of many of its citizens. So there was a need to cooperate to guarantee the timely implementation of the climate law. In Otaferatus versus France, the Administrative Court of Paris recognizes the reversible nature of the greenhouse gas emissions in scales of time that are relevant for the government decision making. So that justified a remedy being imposed expeditiously. At the international level, in 2020, the UN Human Rights Committee issued a communication about Yohan de Tetiota, which involved an asylum seeker from the island of Kiribati, whose situation had become precarious due to the rise in sea levels due to climate changing, and whose asylum request was denied by New Zealand. In its communication, the first decision about the asylum application to climate change, the Commission recognized that there could be an imminent and mortal danger as a consequence of this, and that the situation is becoming even worse. Within 10 to 15 years, where the increase in sea levels might turn Kiribati into an uninhabitable place, the responsibilities of states might soar, and they might have to receive many more asylum seekers. All of these decisions show that the human rights system has necessarily been the accelerator clause that was excluded from the framework of the climate regime. So you might wonder what the specific legal consequences are of this situation with climate change. In closing, we would like to underscore three different types of principles and specific regimes in having to do with the climate emergency that are an opportunity for the court to resolve. First of all, irreversibility of climate change, the need for progressive measures to stop it, and also intergenerational justice. This calls for a perspective, a forward-looking vision of human rights that pays special attention to future damages that must be avoided, and also to prevent more victims from being made by climate change in the future. As to irreversibility, we believe that there are two concepts. First, there's the concept of enlarged imminence. The case here is Neubayer by the Constitutional Court of Germany. According to it, to the state, the claimants were only under threat of future damage, and that was rejected by the court because the possibility of imminent damage is already a damage itself. And so there's the issue of imminence that links the future to the present. And as the court said, the damage is present when a course of events, once initiated, can no longer be corrected. The second rule that stems from the irreversibility of climate change is the need for a reinforced precautionary principle, which is an obligation under international environmental law for states, and that becomes even stronger in the case of irreversibility. This refers to the Uganda case. Climate change constitutes a clear and present danger and can pose a risk for life, and the possibility of this risk materializing means that appropriate measures must be taken according to the precautionary principle. As to the forward-looking or progressive nature of these obligations, there's no need for a new principle to be created that already exists in international or inter-American human rights law, but it needs to be reinforced. However, this reminds us of the case of Fundo Clima before the Constitutional Court of Brazil, the Supreme Court, where it said that it is essential that action be taken to avoid regression. And this leads to very specific conclusions. The national carbon emission targets must always go on the rise without coming to ups and downs. And also, as part of the principle of non-regression, there should be a detailed plan as to how and when these targets will be attained. The plans for 2030, 2040, 2050, and also intermediate targets, as was established by the Constitutional Court of Germany, the Neubayer ruling. Although Germany had a satisfactory target in the medium term, it was violating the rights of these young claimants because there were no intermediate targets or an explanation of that. So the devil is in the detail, literally. In closing, there's something that has been brought up several times in this session, which is the intergenerational aspect of climate justice. And going back to Neubayer and the German court, the human rights are intergenerational freedom guarantees. States say that the measures against climate change, such as restricting the exploitation of hydrocarbons or others, would violate today's citizens' rights, economic rights and rights to property, etc. But if if no action is taken now, then future action will have to be much more dramatic, and the restrictions for future generations wouldn't just be paying more for gas. They would have to give up on a dignified life because they'd have to leave their homes or put their lives on the line due to heat waves. So there's a need to strike a balance between the rights of present and future generations, and that requires deep and urgent measures to be taken in face of the climate emergency today.
Thank you for your participation. We now have time for questions from my colleagues. First, I would ask Judge Patricia Perez Goldberg whether you have questions. No, Madam President. Judge Veronica Gomez. Yes, Madam President. First, I have a question for ClientEarth.
To Ms. Klings and Ms. Marignac. Very shortly, exterritorial adaptation obligations of state in practice, in a nutshell. How do you do that?
In respect of corporate activities?
State and corporate, sometimes, we have corporate activity and we have joint activity, state corporate, so.
Absolutely. Thank you so much for the question, Judge. Fundamentally, we agree with many of our colleagues who have made submissions today that the state's duties to prevent climate change, both within their territory and extraterritorially, must be related to the temperature goal of the Paris Agreement as a minimum standard and a minimum threshold. But in order to be effective, such measures must also regulate effectively the behaviour of companies, both operating within the jurisdiction, so extracting fossil fuel products within the jurisdiction and exporting those to global markets. Also, companies that may be domiciled in the jurisdiction, so have their headquarters, the corporate group head, and therefore essentially the controlling mind of the corporation within the jurisdiction. And also finally, finance. Crucially, states must limit finance to fossil fuel activities and other activities that contribute to climate change, and that's also a principle to align finance flows with the goals of the Paris Agreement. That's also contained in the International Climate Change Framework.
Thank you. You mentioned the UN value chain emissions principles. Those have a role as well?
That's right. So the United Nations guiding principles set out obligations for businesses, but they're quite clear that the obligations extend not just to the borders of the business but also to activities and impacts occurring within the supply chain. So that could be, for example, impacts on human rights of suppliers, and companies are expected and do have complex due diligence processes to address impacts related to other human rights in their supply chains. But they also have an obligation to address human rights impacts from climate change in their supply chains, and that means that includes the downstream sale of their products. So where they sell a product that is inherently going to cause the emission of greenhouse gases, they must also mitigate that. When we say that should be through the implementation of corporate reduction targets.
Thank you very much. Analisa Samayoa.
Analisa Somayor, we're still talking about corporate considerations, corporate capture specifically. The matter of credits with confidentiality clauses. Could you tell me a little bit more about that? Thank you for your question, Your Honor. Based on what was said by the organizations that were included in our written observations, we have found that to a great degree, because of the lack of any regulations that govern certification, emission, and trade of these carbon credits, they have ended up being done they've ended up in the hands of private companies, and the result has been a number of human rights violations, for especially affecting vulnerable populations, indigenous groups. When these projects are set up on their ancestral lands, and also the representatives of the peoples have shared, as the indigenous representatives will tell you at the hearing in Manaus. As for your question, because they're negotiated by private parties, these carbon credits, these contracts for carbon credits, are not negotiated taking into account the right to prior, free, and informed consent by indigenous peoples, and very often they are done through negotiations with intermediaries, with non-legitimate representatives of the peoples, and in the end, contracts with private entities in a language that is not spoken by the communities, containing clauses that block any access to information, clauses for arbitrage in case of dispute settlement, but that would take place in other countries, which blocks access to justice for communities. And also, there are a number of effects that injure the rights of indigenous peoples affected by these initiatives. For example, they experience displacement, loss of their ancestral lands. They do not benefit from the sale or trade of these carbon credits, even though the projects are set up in their own territory. Thank you. If I may, I would like to ask my colleague Veronica to add something to that. Yes, I just wanted to add that very often in these cases, they are not given even a copy of the contract. The communities do not receive so much as a copy. They do not know under what considerations the prices were set for these credits. For example, when forests are conserved, they don't know how much they will receive. They have no certainty. And there is no one available to explain to them or to translate the information, which very often is very technical, and they do not understand what it means. So we are also talking about that. Thank you. Good, thank you. We had 3 statements that talked about time. I won't talk to all 3 of you, and I'm certain that my colleagues will have many questions for Dr. Jaravito, so I won't do it myself, because I'm quite certain that you will be hammered with questions by my colleagues. However, taking advantage of the fact that Professor Zelke is with us, and also the comments by Romina Colotti.
Professor, you spoke about time, about tipping points, which they have been mentioned, but not in detail, and you gave some examples as well. This morning, there was a lot of talk about 1.5 as a guardrail. I think we all take that concept very clear in our minds. But you also talk about the catastrophic tipping points, and they're very close to the guardrail. Very, very close. Could you explain just a little bit more about that?
Yes. If you look at the paleoclimate data back through ice cores, tree rings, sediment samples, we can see these tipping points in the past. So we have a very strong indication they will occur again in the present or the future. We see that the temperatures in the paleo records where the tipping points occurred in the past are about the temperature where we are today. So there's a correlation there that is extremely frightening. And we also see that observational data, looking out the window, is showing us that some of these tipping elements are coming into play already. The Arctic sea ice is one, the West Antarctic ice sheet. So the Antarctic, we had a warming anomaly just recently that was 38 degrees centigrade warmer than the average. Now, that's in the Antarctic, didn't kill people at that point, but that just shows the instability of that particular tipping point. So we are extremely dangerous territory. The Amazon is another one. I mean, the great scientist from Brazil, Carlos Nobre, has studied very carefully how much more the Amazon can withstand. We've lost, or the Amazon has been destroyed by about 17%. And Carlos and other scientists say that when the Amazon reaches 20 to 25% destruction from warming and from further cutting, that it will turn into a savanna. And that will allow the CO2 it's been storing to go back into space. And that's going to warm us up further. So a self-amplifying feedback.
Another Sahara Desert, then.
But that's what's in the future.
Okay, thank you. And last question is for Romina Piccolotti.
We have talked about how the IPCC, you said yourself, that the higher temperature, less ability to adapt. Do we need to generate a practice, for example, of adaptation of law as well, of judicial processes, substantive law, as you said, and also procedural, adjectival law, in order to understand or to cover the time frames of the emergency or the urgency. I'm sure this will come up again when we have other questions. But is that what we need? That was my impression after I heard you. Thank you, Judge Gomez. Yes, the fact of the matter is that we are facing this extraordinary situation. Humankind has never before been in this situation. The processes we have need to be adapted if we are to respond to the emergency. Judicial processes, and also we need to limit the capacity of the executive branch. Today, executive branches are the ones who decide how and when to take action for to address this emergency, and I think the Inter-American, this is a landmark moment in the Inter-American system. It has to do with cutting the discretion held by the executive branches. So damage, time, and the courts need to be able to receive these things. I think this court, the way you have organized this advisory opinion with the support of the Secretariat, I think there's a reason. We're talking about precautionary measures or provisional measures of 3 years, 5 years, 10 years, but we have only 3 years to discuss the measures necessary for addressing this emergency. So yes, the answer is yes. So what you're saying, you're talking about re-signifying state policy, right? Yes, both administrative and judicial. Thank you. No more questions.
Thank you, Judge Gomez. Judge Perez Manrique? Yes, Madam President. The representatives of the School of Law of New York referred to a study on the status of jurisprudence in the world in matters related to the climate emergency. And it then gave some consideration to the three elements that have been developed by jurisprudence: irreversibility, progressive or evolutionary nature, and the intergenerational character. Based on that study that you have conducted, I'd like to know how courts, international courts, have reacted regarding the principle of intergenerational solidarity, and especially everything related to standing and legitimacy of future generations in these types of procedures. So if you could please expand. Yes, gladly, Your Honor. The principle of intergenerational solidarity has been the object of some of the very interesting cases and judgments of several litigations. I've mentioned Neubauer quickly, but several cases have been submitted on behalf of young people, and we have the database, so I can gladly highlight that. The way courts that have gone further in articulating this principle into facts is the following. And also to address Judge Gomez's question, the concept of human rights consistent with the climate emergency has to place the same priority for present and future generations. On a more orthodox reading of the human rights system, you could perfectly follow the letter of treaties and soft law conventions on human rights and leave a planet that is uninhabitable for future generations. So what some courts have done, such as Neubauer, but also the Supreme Court of Colombia in the case of future generations, and as the Committee for the Rights of the Child in CEJIL, is to extend the duty to protect to first cover young people. The Special Rapporteur of the UN on Human Rights and the Environment, John Knox, the first rapporteur, issued a report where that understanding was included. And a pragmatic way of speaking to future generations is that we will protect the rights of young people and children, because they are the people that will live if we follow the same path that we are having today, the worst of the climate emergency, without having to get into standing or thinking about unborn generations. However, other courts have gone further, such as the Court of Colombia in future generations and the Court Neubauer in the case I've mentioned. And they have done so by accepting standing of those generations through different mechanisms, through associations that represent young people, such as the Fridays for Future movement. They have been plaintiffs in a series of these cases. In the case of CEJIL, it was a group of environmental activists, young activists, speaking for young people already born and generations yet to be born. So active standing and legitimacy has been one of the innovations in these procedural cases. It's very interesting, and I believe it's an innovation that is here to stay in international human rights law. Thank you very much. This is a matter that concerns me very dearly, because there are difficulties in the system. Systems are very orthodox in how they function. They apply laws rigorously and in their responses with punitive action, for example, and who is or who can be the support of that right to promote this type of collective action for protection. So there are undoubtedly judgments on the matter, but maybe not necessarily recorded how many times cases have been rejected because of standing or lack of standing. So that's why I was asking. If I may, it is true, there are several cases where courts have held for two reasons that plaintiffs for future generations don't have active standing. And one is because it is not proven that they have suffered a specific damage. It's just the same damage that any present or future being will suffer, because we all will suffer from climate change. And secondly, because it's not generations that can appear before a court today. That debate has been helped or covered through the gradual affirmation of intergenerational responsibility. And in the Neubauer case, it went so far as to say that future damages, when irreversible, can be interpreted as present damages, because you do not have to wait until it is irreversible for someone to go to a court to protect the interests of young or future generations. And based on your oral submissions and your written report, the court can conclude that this study of global jurisprudence is somehow first determined in these three pillars that you've mentioned, or the three foundations for future environmental justice and protection from climate change. But do you understand this as a model that could be generally applied? Yes, we are proposing that these measures, these characteristics of substantive procedural law and human rights law and environmental law should be complemented and refined, considering the specific features of climate change and the unique sense of time of climate change, as I've presented. And in that procedural model, what role would the dimension of time play? Time in terms of how long the process takes? Because that would come with a second question I would like to ask. Go ahead. In several cases, including the case that was recently decided by the European Court of Human Rights, these litigations are brought as matters of urgency. The case of Fondo Clima was treated by the Supreme Justice Court of Brazil with the understanding, as we heard from Romina, and the court is understanding the fact that these cases cannot wait. Every year, every day that goes by is vital, and that way we can avoid irreversible damage. So I believe this is a procedural rule, a principle that is being used in the sense that you are creating a more expedite manner to decide on cases such as this. Now we have the other question then, and then I'll leave it at that. Don't worry, I had to wait until the end of the day, so I have time. Well, we can't be very calm because of the climate emergency, but my question is, we are talking about procedural standards or models where time is a factor that has a vital role. How would you apply that to the international system of human rights protection? That's a difficult question, of course. Obviously, we have to balance principles of such as one of subsidiarity, such as the principle of celerity in the decisions of these cases. If you have not had the opportunity, you may read the decision of the European Court on Human Rights. In the case of Duarte Agustino, it did not accept the argument looking to accelerate the complaint against 33 states under the jurisdiction of that court. And the plaintiffs, young people from Portugal, held that if they were to go through the procedural instances in each of their countries, their lives time would run out. And then by definition, they would be denied their fundamental rights. The European Court, as you know, did not accept that argument However, I believe, and again here is an invitation very respectfully to this court, I believe that the European Court of Human Rights, even in the case of Klima Senioganen, was very short of doing what it should have. It has been celebrated as a milestone in jurisprudence, and it should be, but if you look at it in detail, it is very much behind domestic courts even, such as courts in Germany, Colombia, Brazil, the Supreme Court of Mexico in certain cases, because it was very timid in defining who counts as a victim. It rejected certain petitioners that were in conditions of vulnerability and where many of our legal regimes in Latin America would have counted them as victims. So although this is not a direct answer to your question, which is very complex, I believe, and here I have the advantage of not having to decide as a judge in these cases or advisory opinions, but just be an academic, I also believe that you have to update these rules and think about how to accelerate these cases, because if not, the time gap is just insurmountable. Thank you very much. Professor Piccolotti. Along the lines of what I was asking, you've also referred to a model, in a way, for processes in systems of justice, a procedural model. So my same concerns in terms of standing, time, and what the response should be by a system, an international system of human rights protection. I'd like to hear from you. Thank you, Your Honor. There are internal measures that are incremental, that are very significant, and then there are more substantive measures. These are essential for me because of the emergency, the urgency. Incremental measures is to acknowledge active legitimacy. It's a trend, as the professor said. We already have the organizations, we have ombudspeople's offices and the like. The state does not have to do much more than they're already doing to provide representation to future generations. It's there's a clear, with a clear line from the court in the advisory opinion and dialogues between this court and judges of Supreme Courts and constitutional courts. That is something we can progress on very much in the standing of future generations. Then another important aspect is real access to justice with effective resources in reasonable timeframes. And there, what we propose is also practical, but it entails modifying current practices, which is the reversal of the burden of proof and establishing very specific short time frames. And maybe this court could establish a system of indicators after the advisory opinion so that states may periodically report about their cases and when they are solved. That might be an additional incentive for local courts to solve these cases quickly. The third point that I believe is crucial is modifying current criminal codes to legally pursue the CEOs of companies that are causing the most damage. There we have severe limitations in that sense, and so criminal law is being used to pursue environmental defenders very effectively, and we don't have any recourse of using criminal powers of the state to pursue those who are truly causing damage to all. So that would be a substantive modification or a modification of substantive law. And the other question on the specific impacts in the inter-American system, we have to say it clearly, precautionary measures before the Commission takes so much time. I wrote the petition of La Oroya. It took us years to litigate this within the Inter-American system, not through the court, and because of the court, but because of what's happening in the Inter-American Commission. So I believe that this court also, in its advisory opinion, could provide very clear lines to the Inter-American Commission of the need to accelerate these cases and even have a specific deadline or time frame for precautionary measures. They cannot have precautionary measures for 6 or 7 years in the Inter-American Commission. with violations of the right to life. Thank you. It's just a very respectful suggestion, of course. And the right to resilience. Is it a right in its own, or is it derived from the right to life? The question is, what would be a distinctive or differentiated role or contribution of using it as a right in itself, or what would be the uniqueness it would have to consider it as a right, or and not just a consequence of the right to life? It might seem that the right to life, that states have the obligation to respect and guarantee the right not to violate that right. So what would be the specificity that brings you to suggest the existence of this standard with different characteristics? Thank you for the question. Very interesting. And actually, it has been very difficult for us, I have to say, with Diana and the whole team, including Professor Zelke. What is the added value, if you will? We've done much consultation in that sense, if it would have an added value of seeing it as an independent, standalone right. We are in the era of resilience. States are more and more being forced to protect and to build resilience. The added value is given because of what we recently mentioned, the tipping points. We believe that a standalone right to resilience protects a matter of general interest, of universal interest, which is that the elements of the climate system that we have to protect to be able to build resilience, and that are not necessarily linked to an individual right. For example, as Professor Zelke mentioned, the Arctic, the Amazon, and different thermal currents. If we lose that, we are in the midst of irreversible change and absolute climate instability. It's impossible to build resilience that way. Linked to the right to life, it's the right of a human being or a group of accessing resilience. So it's very much linked to human beings. The other one is more connected to what we heard in questions from the court by Veronica Gomez, especially by Judge Gomez, on the obligation that human beings have to protect more than just human life, but the life of all ecosystems that are also essential to life. Therefore, we understand that it is a quantum leap for the court to have a standalone right to resilience. But the court has taken quantum leaps with the right to the truth and to identity. But it has taken many years to build these standalone rights, and here we don't have the time. So it's up to the court to decide what road to take, and it does have the alternative of interpreting the right to resilience of a component of the right to life. One final question for you, and then also to Aida. And it's in a different plane that from the one we've been discussing. Your institute is called Institute for Governance and Sustainable Development. What are the global governance issues, or national even as well, that have led us to where we are? Or what changes are necessary to reverse this situation globally and nationally? And the same question to Aida then, because all the matter of vulnerable groups and investment contracts is related to governance. Who sets the rules? And then if you want to answer as well, who sets the rules of the game? Who determines the scope of obligations and rights?
Thank It is the question that's preoccupied me for much of my long career. I'll give a couple of illustrations. I mean, the UN Framework Convention on Climate Change, Kyoto Protocol, Paris Agreement, these are ineffective governance systems. We started 30 years ago, and we've seen climate emissions go up by 50% in that time. The voluntary nature of that governance approach has not worked. The best you can say, and this is what many of my colleagues would say, it could have been worse. But that's no longer acceptable because it will be worse really quickly when we pass the tipping points. The one international governance system that has been stellar in its climate performance is the Montreal Protocol, the treaty that was originally designed to protect stratospheric ozone. But because the same chemicals, CFCs, HCFCs, and now the HFCs, those same chemicals are super climate warmers as well. And so by taking them out of the system with the Montreal Protocol governance system, that treaty has avoided as much warming as CO2 causes today, which is a little more than half, 55%. And that treaty, Montreal Protocol, has kept us from going over the cliff of tipping points so far. It is on course to avoid 2.5 degrees of future warming by the end of the century. That's 1.7 degrees from taking out these fluorinated gases, and another 0.8 degrees because by healing stratospheric ozone and preventing UVB radiation from coming in and destroying forests and other sinks, we have gotten an extra benefit from this treaty, 2.5 degrees. So it is the stellar example. It shows us how you can construct effective governance. It's a universal agreement. It's been ratified by every country. It's been amended 5 times, and it's a rockin' treaty. Now, the next challenge for governance is how to address methane. We have promises that have been made by national oil companies and others for many, many years that they will take care of their methane problem. But that's no longer sufficient to rely on a promise. And it's time to move to a mandatory methane agreement inspired by the success of the Montreal Protocol. It's inevitable if we're going to slow climate change in time. Thank you.
Muchas gracias.
Thank you. I would like to ask Aida to also answer because otherwise my colleagues will not be able to ask any questions. Thank you, Your Honor. Briefly, because after what we just heard, I mean, I'm even embarrassed to add anything to what was just said. But what he said about the voluntary nature of these contributions and the fact that these are non-binding is already an issue. And also the interference by players who have an influence on the regulation of their own activities on their when they're the ones responsible for the emissions of greenhouse gases that cause these effects. Practices such as revolving doors, where people who worked for companies now work for the governments, interference with the legislature and with the judiciary. that leads to the enactment of laws that favor companies, and also judicial court rulings that favor these companies are flaws in the governance that may be repaired to put a stop to climate change, as we just heard from the professor. I don't know if you'd like to say anything else, because I mean, I've been on for a long time, but
very short. I believe that the failures in global environmental governments really stem from the fact that emissions and climate change are a cumulative problem, and the tools of environmental law have proved inadequate to deal with this global cumulative challenge. For example, environmental impact assessment, of course, only examines emissions at the project level, and states have so far failed. And they've been enabled by the territorial limitations of the United Nations Framework Convention on Climate Change Greenhouse Gas Accounting Framework, which requires states only to report emissions within their territory. Therefore, states have only looked at those state policies, and they have failed to adequately regulate the source of emissions, which are often through the actions of the multinational corporation, which is, of course, operates across borders, whereas state powers are very much myopic and looking at that state level. But as I mentioned, this failure to regulate corporate conduct can no longer, I think, stand scrutiny, particularly when looked at through a human rights lens, and states must therefore take all effective measures. And this goes to the effectiveness principle that states provide the financial support and architecture to enable greenhouse gas and fossil fuel use and extraction and production and sale. They provide access to capital. They allow companies to list on their stock markets. So there are a range of measures that states must also take to ensure adequate emissions reductions from the corporate sector that have so far been lacking. Thank you.
Muchas gracias.
thank you. I have no further questions, Madam President. Thank you. Judge Ferrer McGregor, do you have any questions? I just wanted to thank all of those here for their very valuable and interesting contributions. Thank you, Judge Ferrer. The Vice President, Judge Mudrovich, any questions?
I did not have any. However, I think I do have now. And trying to be very brief. And again, thanking the speakers. I'd like to insist on some points that have been already asked by Judge Perez Manrique. And also, for the benefit of the usefulness of this advisory opinion, I have to be quite honest. To each answer given on the human right to resilience, I am more and more convinced that it is rhetoric more than a need. I have no resistance to standalone rights. We have recently a very important judgment of the court, and we acknowledge a new standalone right, and I understand for the hermeneutical logic that helps us and the specific importance that it has, but I don't see how to compare the human right to resilience to the right to the truth. I can't see that quantum leap that has been mentioned. And precisely because I respect the arguments that have been presented, and also because I very much respect all these speakers, I would like to discuss this once again, because I could always be mistaken, and I'd like to once again try and see if I can understand the importance of the proposal.
Muchas gracias por la sinceridad.
Thank you for being so candid. I think that this is a very fruitful dialogue, actually. Resilience, according to the latest reports from the IPCC, I mean, they have been on resilience, and there are specific definitions of resilience. So the content of resilience is scientifically based. I can't imagine, and let's say in the face of a climate emergency, as is the case at this moment, I cannot imagine how this court is going to hear the clamor for resilience, and it will help states. States are very, they're divided and they are not really focused on the emergency. They're thinking about electric vehicles, etc. They don't know exactly how to stop the emergency. So the human right to resilience will help focus all public policy. So this investment that I'm making here, let's say, does it help with resilience or is it exacerbating the climate emergency? So it would basically organize public policy as a framework of sorts. So if it can it be interpreted as an element of the right to life? Yes, of course. It is true that in some aspects that will not be enough. It will not be enough for issues that are coming, such as the melting of the Arctic caps, the ice caps. It will be hard for a victim from Barbados to argue before a court that the rising sea levels in 30 years will affect their right to life now, That would be overstretching the interpretation of the right to life now. If there was a right to resilience, it would be easier to have more of these cases. So it's a contribution to this court that we are making. And I am willing to continue to contribute together with Dinah in arguing for that right to resilience. But I would like to invite you to look at the IPCC's definition of resilience, Your Honor, because I believe that can help think about it and see how to adapt human rights law to the need for resilience that will.
Muchas gracias, Juan Mudrovich. No, bueno, en aras del tiempo, solo una breve.
I just have one question for ClientEarth. A few hours ago in the European Parliament, there was discussion about due diligence on environment, human rights, and sustainability. So what's new? What are the specific new issues in substantive law?
Sorry, just for clarification, because the translation cut out briefly. Did you say there was a discussion earlier on, and you were asking about our comments on the CSDDD?
On your comments?
Thank you for the question. So the Corporate Sustainability Due Diligence Directive does cover a wide range of human rights and environmental impacts of all businesses over a certain size operating in Europe. So what's particularly new about the regulation is the coverage. So it includes large companies of a certain size operating within the jurisdiction. So it will capture many American companies headquartered in the US and in other regions of the world. So the coverage is quite important. It also codifies for the first time the obligations of companies to conduct human rights and environmental due diligence and specifies how they ought to do that. And particularly for climate change due diligence, which is Article 15 that I referred to, it sets out specific requirements for transition plans. The transition plans must include time-bound targets for 2030 and in 5-year steps up to 2050 based on scientific evidence. This must be for Scope 1, 2 and 3 emissions. The transition plan must include a description of decarbonisation levers identified and key actions planned by the company to achieve those targets. It also must include an explanation and quantification of investments and funding to support the achievement of those targets, and the role of the administrative, management and supervisory bodies, so the governance within the company on how they will achieve that target. So this is quite a detailed provision, and we expect that other jurisdictions globally may move towards similar mandatory requirements over time. Thank you.
Gracias. Le entendí que es un gran aporte, pero que
I understood that it's a great contribution, but it doesn't cover everything. What doesn't it cover? What's still missing, in your view?
So the directive is not perfect. It limits the coverage of human rights and environmental impacts to a particular list that's included in the annex, and that list is much reduced through the debates in the European trilogues. It also doesn't cover the full range of small and medium enterprises. It really focuses only on the largest listed companies. The obligation in Article 15 is also an obligation of best efforts, and we at ClientEarth proposed that the obligation be a requirement, a mandatory requirement. And the obligation to include Scope 3 emissions there is some flexibility for companies to interpret these laws, but of course we'll have to see how this plays out in the implementation phase in the next few years.
Muchas gracias.
Thank you. With this we complete the hearing for today with this panel. We would like to thank all of you for your valuable contributions to this advisory opinion. The hearing will continue tomorrow, April 25th at 9 o'clock in the morning. Thank you and good evening. Please rise for the court to take its leave.
Oh no, I think I could have done a bit better.